of wood or debris shot out of the number 4 bomb, overtook a rotor blade that was going around at 760 RPMs, had an impact of in excess of 7,000 pounds.
John, I think Mr. Brown may have spoken.
I don't think I did.
Okay.
I'll object to the question in any event because it's irrelevant to this witness's expertise.
I'm going to ask Mr. Braun to rephrase
Right,
the question. Rephrase the entire question.
Okay, Mr. Neal's right, Your Honor. It's always the first time.
I'm glad to be right.
Okay. Let me go back to basics. In looking at this data, you must have had different hypotheses that you tried to see what happened while you were figuring this out with the FBI. Isn't that correct?
That's correct.
Okay. Now, if we assume a hypothesis that right now or then, that an object came out of the number 4 bomb fast enough to catch up to the trailing edge of the rotor blade that's going around 1,750 RPM, and even catching up with the trailing edge of that rotor blade had enough force to impact it with over 7,000 pounds force. If you assume that hypothesis, isn't it a fact that there is no sound between point 9098 and say 9.70 that is consistent with that hypothesis?
Objection. That assumes facts not in evidence, unintelligible.
Sustained. You may ask the last part of that question.
Isn't it a fact, Officer Melvin, that between 9.09 and 9.70 that you have no sound on that track that would indicate a violent impact to the trailing edge of the rotor blade?
That's correct.
No further questions, Your Honor. Thank you.
All right, any questions, Mr. Sanders?
Yes, Your Honor, just a couple. Sergeant Melvin, my name is Jim Sanders and I represent John Landis.
Yes, sir.
As I understand it, from your first set of tests, or at least the first ones you told the jury about, you made a comparison as to frequency between a 12-inch mortar and an 18-inch mortar, correct?
Frequency content.
Frequency content.
Yes, that's
You'll have to be patient with my phraseology.
Yes.
Is that right?
That's correct.
And the 18-inch mortar was a square mortar, correct?
That's correct.
And you determined from your test and your comparisons of the frequency content that the mortar, the number 4 mortar, the 4th mortar shot in the accident sequence, was a square mortar, correct?
That's correct.
And then the number 5 one that was shot was a round mortar.
That's correct.
And then I think using your chart, could you help me here just a second? Your map, your diagram is what I'm looking for.
Diagram.
Your map of the village, where you place the mortars. It's Exhibit 88. You determined that, in further checking and other tests that you were doing, that 4th explosion came from this point right here, which you labeled number 4 on exhibit number 88, correct?
It's the part underneath the square indicating the hut.
Right, it's the square inside the square.
That's correct.
And you've got a 4 written right underneath it.
That's correct.
And that you determined was a square mortar.
That's correct.
And this mortar over here, which is designated by a black dot filled in, to the right side of which you put number 5, you determined that was a round mortar.
That's correct.
Now, in doing those comparisons, you originally testified that you were asked to compare the size of the charges in those explosions and perhaps the amount of gasoline in them. Is that correct?
That may have been the original request, yeah.
Right. And the fact is, you couldn't really do that, could you?
That's correct.
But you could tell a difference between what black powder would do on your charts and what dynamite would do, right?
That's correct.
You could tell that difference, but you couldn't tell a difference between, on your charts, between a 6 ounce, an 8 ounce, or 12 ounce.
That's correct.
Okay. But there's no doubt in your mind, based on your study and analysis, that the number 4 mortar that we've shown you on there, that's a square mortar.
That's my opinion, yes.
Okay.
That's correct.
And you conclude from that 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 means the tail rotor slowed down.
That's my conclusion, yes.
Right. Okay. Now, you don't know why it slowed down, do you?
The main rotor of the helicopter and the main turbine of the helicopter was maintaining its proper speed. And the only reason for the tail rotor to be slowing down is if it had become disconnected from the shaft.
Or could it possibly be that there was something that was sticking up from the airfoil that was causing it to slow down gradually, or slow down some? Doesn't necessarily have to be off, does it? It's just something that slows it down. Isn't that correct?
I don't think that's possible.
But if anything that would slow it down would show you what you see on there, right? Whether it's off or not.
Excuse me, let me have that last question read back.
Question, but if anything that would slow it down would show you what you see on there, right, whether it's off or not.
Ask a new question.
Good idea, Your Honor. My question to you is, based on what you know about helicopters, you might not be able to tell what would be possible to slow a tail rotor down, right?
I might not know the cause, that's
Right.
correct.
You would admit to the possibility that there are things that would slow a tail rotor down other than just coming off, wouldn't you?
Well, if I can qualify the answer by saying that in order for it to slow down, it has to be disconnected from the shaft.
Well, that's my question to you. You can think of no other reason why a tail rotor would slow down on a helicopter except coming off?
Objection, that's not what the witness said. It's a
Sustained.
statement.
I misunderstood then.
Well, if you want him to, if you want to define what you mean by coming off, or ask him to define it, then you can go from there with that
Okay.
question.
Okay. When you say when the tail rotor comes off, that's the only reason you would know of to cause that deceleration that you noticed on your charts. Is that correct? Am I correct in that?
The tail rotor could still be on the craft, but the drive shaft broken. And that could still cause a deceleration in the tail rotor.
Okay. All right. So the tail rotor itself could still be on the craft, but because the drive shaft might be broken, it would be slowing down.
That's correct.
Okay. Now, another reason it could slow down would be because part of the skin was peeling off and caused an air drag and slowed it down for the same reason. Isn't that right?
If the drive shaft was broken.
Let's say it's not broken. Say the drive shaft's not broken.
Then I
And
can't.
part of the skin of that tail rotor starts to come off and there's a drag on that tail rotor. Wouldn't that slow it down?
I don't believe so. I believe it would have to slow the entire drive mechanism down, and I don't think it would do that.
You don't know how much that tail rotor was slowed down, do you, by simply looking at your observations in your chart. All you notice is a change of sound, right?
That's correct.
Okay. Now, finally, in your analysis to the thousandth of a second, the difference in time, the time lapse between this ignition the delayed ignition or misfire of number 5, and the time when you recognize this deceleration, that's a little bit over 2 seconds, isn't it?
That's correct.
So in other words, from the time that you hear on the soundtrack that there has been an ignition of the gasoline in mortar number 5, or coming out of mortar number 5. From that time to the time you notice a deceleration, it's a little 2.1 seconds or so, right?
That's correct.
Could I have a second, John?
You may.
So he sets off number 1, he waits a little more than 1.5 seconds and sets off number 2, correct?
That's correct.
Then he waits a little less than 1.5 seconds and sets off number 3. Is that correct?
That's correct.
He's still within 1 to 2 seconds of delay between 1 and 2 and 2 and 3, right?
That's correct.
After number 3, the helicopter starts making a left turn. Is that right?
That's correct.
And the tail rotor now swings away from your microphone, right?
To be specific, it was the sound engineer's microphone, not my microphone.
All right. The tail rotor is farther away from where the microphone is that's picking up the sound on the movie soundtrack.
That's correct.
And that's how it lets you to know, plus watching the film, that what you're seeing and what you're hearing is the tail rotor moving away as the helicopter makes a left turn, correct?
That's correct.
Then there is a much longer pause before the person on the board sets off special effect number 4, correct?
That's correct.
In fact, something a little over 3 seconds he waits.
That's correct.
And at that point, after 1, 2, and 3, the helicopter is turned left. Everything is fine as far as you can hear as to the helicopter's operation, correct?
That's correct.
Makes a left turn, and suddenly 4 and 5 go off, boom, boom, within 1/10 of a second of each other, right?
That's correct.
And the person setting off 4 and 5 sets them off right underneath the tail rotor as you watch the film. Isn't that true?
I did not do any precise calculations on the position, but just the timing of the events.
But you could see in watching the film that the results of 4 and 5 sent the fireball up right underneath and engulfing the tail rotor. Isn't that right?
That's what I viewed, yes.
That's what you saw.
That's correct.
And it's sometime after that point, that you then hear that there are some problems with the tail rotor's sound, which indicates to you it's having a mechanical problem, correct?
Yes, I recognized it was in trouble at that point.
But after 1, 2, and 3, which you showed are well away from the shoreline, isn't that true? 1, 2, and 3 were much farther away from the shoreline than 4 and 5.
That's correct.
Do you have your little chart of the village?
Is it over there?
Oh. So 1, 2, and 3, right here, here, and here, are farther away from the water than 4 and 5, correct?
That's correct.
And in fact, your calculations showed, as you showed us before, the distances from the cliff that 1, 2, and 3 were as opposed to 4 and 5, right?
That's correct.
And number 6, you've got way over on the left-hand corner, correct?
That's correct.
So it's fair to say that number 6, in your opinion, really had no impact on the helicopter one way or another.
Objection calls for speculation outside this witness's expertise.
Sustained.
All right. In any event, 1, 2, and 3 go off where you've got them numbered. The helicopter is fine. It then turns, makes a left turn, and whoever's on that board sets off 4 and 5. They join because of the misfire and engulf the tail rotor of that helicopter. Isn't that what you saw and heard?
That's correct.
Thank you. I have nothing further, Your Honor.
All right, Mr. Anderson?
Thank you, Your Honor. I'd like to begin by marking a couple of exhibits. What's my next number, please? And tell me, if you can, which was a larger explosion? At least in terms of sound.
That cannot be done,
Why not?
because there's no guarantee that the recording that made these bombs did not have a protection of overload on the system. So a larger sound may appear to be the same level because the electronics in the recording equipment will attempt to make them not overdrive the system.
Okay, but bomb number 4 does not come anywhere near that limit on the machine, does it?
Object, that's unintelligible. I can't comprehend what's being
Well,
asked.
it's intelligible. I think there's no foundation for the question as yet, not as to his expertise, but as to determination of such and as to the machine.
It was calibrated that night, would record sound at that amplitude, right?
It did record that, yes.
Bomb number 4, neither one of the peaks at least reached the limiter, isn't that correct?
That's correct.
And the marking bomb number 1 in your hand, do any of those peaks climb up 3 lines worth of graph paper?
No, they do not, but that doesn't mean anything in relating the one to the other.
There's not the fact that we got a sound registered 3 lines worth on the graph paper with bomb number 5 indicate that the limiter comes into effect at a higher sound.
If that's the way that it behaved, but it could be an adjustable thing that activates at different ranges depending on the ambient sound that's being recorded.
All right.
The term is automatic gain control, and I wasn't certain whether that was present or not in the system, and therefore I didn't make any determination on the amplitude of the signal, because it would be unreliable. In my opinion, that this is where the ignition of bomb 5 occurs. However, the amplitude of bomb number 5, the trajectory of this peak, may have a combination of effects such as the combined echo from the previous bomb may have added to this particular spike. So I'm unable to determine whether this amplitude is solely contributed to by bomb number 5.
In other words, what you're telling us is that audibly, because the 2 events were so close together, you can't necessarily discriminate between one or the other. Is that?
I can tell that there is an ignition here of one device and another, but that the amplitude, the absolute amplitude of the 2, I'm not able to determine.
All right, let me put up our voltage diagram again, exhibit 88. You remember, sir, from your study of the film, the tail rotor's movement was generally toward the number 4 and 5 mortars, was it not?
Just prior to them being set off.
Correct. And at all times, the number 5 mortar was closer to the tail rotor than the number 4 mortar was.
I personally don't know that exactly. sounds of an explosive, very impulsive type sound, an impulsive sound is something like a clapping hand, a slamming door, a gunshot, or a bomb. That's an impulsive sound. That type of sound I detected 4 different occasions, but because the video screen was completely whited out from the previous explosions, I was not able to verify exactly where they were coming from, but merely the times. And I've indicated that there could be a small margin of error in these times. But I've indicated 4 areas of different explosions at 11.200 seconds. I'm sorry, I'll split this up for you. 11.500 seconds, 11.725 seconds, and 12.725 seconds.
Let me stop you for just a moment there, Sergeant Melvin. So this barrage of explosions, you're able to detect in that barrage at least 4, and allowing for the margin of error that you indicated. Within those 4, the time difference between 1 and 2 is 0.300 of a second. Is that correct? Or about 1/3 of a second? A little less than 1/3 of a second?
That's correct.
And between 2 and 3 is 0.225 of a second, or 1/4 of a second, correct?
That's correct.
And between 3 and 4, 1 second. Is that correct?
That's correct.
And what is the amount of time, sir, between the last of that barrage explosions and the water bomb in front of the boat?
That would be a half a second.
And between the last of the barrage explosions and the bomb in the left field of view?
Let me refer to my calculator to be accurate. That's 0.92 seconds between the bomb I viewed in the left part of the screen after the last bomb that I detected in this continuing barrage.
So that would be just under a second, correct?
That's correct.
You have in there also high-frequency sound, possible impact of rotor assembly on ground, and impact of helicopter. Could you explain those 2 sounds, sir?
There was a sound emitted at 15.02 seconds on my timing scale that was of a higher frequency and very hard sounding. And this could have been contributed to either a tail rotor assembly contacting the ground or possibly a microphone itself contacting a hard object. I was not able to distinguish that, but it could have been the actual tail rotor assembly.
And then the impact of the helicopter?
The impact of the helicopter in reference to this timing scale occurred at 17.275 seconds.
Now, in relationship to after the time after the first explosion was set off, how long after bomb number 1 went off did the helicopter crash?
Using my calculator, it was 14.129 seconds.
All right, now, could you tell us how you arrived at that figure, sir?
By subtracting the time of the first explosion from the time of the impact of the helicopter.
Okay, the reason we don't have that is we don't have the time of the first explosion there. You subtracted the 3... Sorry, could you hold that a little?
By subtracting the time of the first bomb, 3.14 seconds, from the impact of the helicopter, I arrived at the figure of 14.129 seconds.
I wonder if you could write that next to the impact of helicopter, sir, on that chart. Indicate the amount of time from first, put the amount of time and then say from time from first explosion to crash.
indicating on red on Exhibit 86, I've indicated that the difference in time is 14.129 seconds.
Now, you may sit down, Sergeant Melvin. Word properly.
It's my opinion that the only reason for the lowering in frequency at the time I've indicated on my chart would be due to the fact that the tail rotor assembly was slowing down. And that could only be due to it actually becoming dislodged from the drive shaft that makes it turn.
Were you able to, based upon your analysis and viewing the picture, come to a determination as to whether any explosions continued to be set off after this change in the rear rotor system?
As I've indicated on my timing chart, there are additional explosive devices being set off after I've detected this changing rotational speed of the tail rotor assembly.
And could you tell from what area of the village these additional bombs were being set off, sir?
Only the ones that I've indicated on that chart were I able to verify their location.
And one of them being the one you've previously marked as number 6, is that correct?
That's correct.
All right. And then down there on the bottom of your time series chart, you have bomb in village in left field of view, is that correct?
That's correct.
And that would be as you're facing the village on the left-hand side, is that accurate?
That's correct.
Let me give you the following hypothetical, sir. If, assume for a moment that the person who detonated the explosions that were located on the left-hand side of the village as you're facing it, indicated that his explosions were fired between a second to a second and a half apart from one another, would that be consistent with your findings?
I object to that. That's beyond the purview of testimony. His chart and his findings are up there, and he can't compare that to testimony in a hypothetical.
The court's objected to us reading testimony the other way.
Yes, I sustain the objection as to the form of the question. You don't have to relate it to what somebody said. If you want to make a hypothetical as to whether or not explosions were 1.5 seconds apart or something like that, you can do that.
Sergeant Melvin, were the explosions that were set off after bomb number 5 set off a second and a half apart from one another?
They were set off at different times, but some of them fell less than a second apart.
In fact, some of them fell with like a quarter of a second from one another, isn't that correct?
That's correct.
And some of those were on the left-hand side of the village, correct?
That's correct.
And based upon your analysis of the sound, sir, and your viewing of the film, did some of those explosions, or were some of those explosions, in fact set off after the helicopter was in trouble? That was not asked and answered, Your Honor.
Rephrase the question as to the in trouble and put it in terms of the motor sound.
Based upon your analysis, Sergeant Melvin, and your viewing the motion picture, were some of these explosions in fact set off after you were able to detect a change in the rear rotor?
Yes, there
I
were.
object to that as they, because it testified to at least 2 changes in the sound from the rear tail rotor. I assume that we mean the change at 11.325 seconds.
Why don't you put it in those terms?
Well, Sergeant Melvin, there is a beginning of sudden acceleration and tail movement towards Myca, correct? You have that on your time series up there.
That was never mentioned, no.
Now, when did you arrange to have the San Bernardino Sheriff bring a Huey helicopter to Los Angeles County for tests?
I don't have a record of the exact date, but it was after that September 23rd date and prior to December 15th when I went to Washington.
You actually flew, the County of Los Angeles sent you to Washington DC as part of this investigation, is that correct?
No, it was at the request of the National Transportation and Safety Board.
Okay, so they brought you to Washington, is that correct?
That's correct.
And in terms of the helicopter that was recorded down in Long Beach, what did you have the helicopter do as you were recording the sounds?
We had it hover and make left and right turns. And that was basically
What
it.
type of left or right turn?
At different rates.
You mean a pedal kick turn?
Stationary, no change in position, but rotating about its axis.
Okay, so what you did is you had the helicopter stay in a stationary position and just simply swing its tail about, is that correct?
That's correct.
But it did not move in a forward direction, is that correct?
Not appreciably, no.
Now, when did you make this comparison between the soundtrack from the accident sequence and the recordings that you made of the FBI test explosives, and determined in your own mind that the number 4 explosive was in fact a square mortar and not a round mortar?
Most of the work was done prior to me going to Washington, and after I had done some work with them in reviewing the film frame by frame, I came back and did some additional work after that.
And so would it be fair to say that your final report then was completed and submitted by the early part of 1983?
That's correct.
Okay. And when you made a determination that it was in fact a square mortar and number 4 was a square mortar, or not a round mortar, did you report this to the Sheriff's Department that was investigating this case?
I submitted the report to the district attorney.
And that would have been in March 1983?
Around that time, January, February. I don't have an exact date.
Now, in addition to submitting the report, do you know when the grand jury proceeding was?
It's been told to me it was somewhere around May of that year.
Now, did you, during May or June of 1983, did you know that there was a grand jury proceeding involving this case?
I was probably aware of that, yes.
Were you ever called to testify before the grand jury?
No, I was not.
Now, could you put on your machine here, number 86, that's your diagram of some of your calculations. And now, looking at number 86, this 0 is simply an arbitrary calculation, is that correct? So you have to start somewhere to calculate, is that right? Before the number 4, Bob, is that correct?
That's correct.
Okay. Now, in fact, you couldn't verify this particular phenomenon from the film, could you?
At this particular time, there appears in the film a large black cloud of smoke and what appears to be debris being pushed down, probably by the downwash of the helicopter.
So it'd be pretty fair to say that you couldn't distinguish whether this was just wind, but you basically are speculating that it was falling debris. Is that
Objection,
correct?
misstatement.
Well, the question is compound in the way that it's phrased and therefore somewhat ambiguous. He may ask the question, but he'd have to rephrase it.
Yeah. In fact, what you saw was in the film that led you to this opinion was the swirling of apparently some black smoke and clouds from the rotor blades. Isn't that correct?
That's what was visible, yes.
Okay, and what your opinion is that could either be from falling debris or it could be wind created by previous explosions. Is that correct?
There was an unusual low frequency developing, and at that time I noticed this large cloud of debris coming down, and I associated the sound with that.
Okay. So you assume that because there was an unusual low frequency developing, that must have been related to the cloud that you saw at about that time. Is that correct?
That was my assumption, yes.
And what are on the soundtrack, in terms of the helicopter, are there any low frequency sounds coming from the helicopter?
Yes, but they're very periodic in nature.
And that would be, the main rotor blade would be.
That's correct.
Okay. Now, did you do any, when you did the recordings of the test helicopter, did you ever have the test helicopter make a turn in which it is also making a transition to forward flight?
I don't recall doing that test, no.
Now, you really never, you've never flown a helicopter as a pilot, have you?
Not as a pilot, no.
Okay, and have you ever done any tests to determine the different sounds that would come from a helicopter as it is not only turning, but moving forward at the same time using its main rotor blade?
I did not perform that test.
Now, with respect to going down further, we have a bomb number 4 goes off, then what? Less than a tenth. It looks like about a tenth of a second later, the bomb number 5 goes off.
That's correct.
And then you have a split second later the delayed ignition. Is that correct?
That's correct.
Now, what you say, the beginning of sudden acceleration and tail towards microphone. What you mean by that, is it not, is that at that point, at time 9.7, the helicopter is in fact, it turned away from the microphone at 6.59 and it's beginning a turn towards the microphone. Is that correct?
That's correct.
Now, when you did an analysis of this, you were working with the FBI. Did you ever see the FBI's chart showing their analysis of the various motions of the helicopter?
Not until after I performed my own work.
And did you compare that with this?
Not specifically, no.
Okay. Did you ever check the FBI's work to see whether or not you simply had a turn towards the microphone or a sudden turn towards the microphone?
I don't quite understand.
Okay. In other words, if a helicopter begins a turn towards the microphone, you would expect a Doppler effect to come up on your soundtrack that would
Yes.
detect that. Is that correct?
That's correct.
Okay. Now, was there anything about that Doppler effect or anything that you saw that justifies where you say sudden acceleration?
The magnitude of the divergence in frequency was what gave me the impression that it was abrupt, and also correlating that with what was viewable in the films.
Well, isn't it a fact that in viewing the films, that in fact that was a gradual, at that particular point, there was a gradual turn?
Are you referring to when the helicopter, after the explosions, began swinging back towards the microphone?
That's right. Or do you have any memory of that now at all? I mean, it's been a long time.
In my opinion, that return turn was more rapid than the initial turn away from the microphone.
So what we would really say then is, and correct me if I'm wrong, what you mean by sudden is that it appeared to be a faster turn. The turn that you call sudden seems to just be a faster turn than the one that you call moving away from the microphone. Is that right?
That was the impression I had when I wrote the report, yes.
Now, we have down here what we call that 11.39. First, let me just go back for a second. When you were at the FBI lab or at any time while you were working on this case, did you actually ever see the tail rotor of the helicopter that was involved in this case?
Yes, I did.
Make a request. If we agree to bring John out, just have him stand here so you can shoot. We're not gonna. No problem. All right, wherever you want.
Right there.
And have a couple of minutes let you shoot the film you need, then can he go on to the elevator without the problem we had at lunchtime?
Agreed, sir, do we agree?
GP. All right, we'll get the marshals to move the GP out.
Back up front.
Gentlemen, back up.
Stay back. Can the attorney move, come that side?
Do anything you want, and
Mr. Landis, can you step forward, please, a little bit?
we'll stand here,
Thank
then
you
you
very
all
much.
let us go, okay, for the day?
Yes.
How would you characterize first day of testimony?
I think that Mr. Landis has been doing his very best to remember and relate exactly what happened in the making of this his segment of the Twilight Zone. I just think he's doing a first-rate job of that. I don't know what the jury, of course, we don't know what the jury senses, but from what I see, he's done a wonderful job of telling his story to this point. We are now getting down to the scene in which the tragedy occurred, and we'll continue that tomorrow morning.
Obviously, by putting him on the stand, it means you're not afraid of cross-examination. So,
By putting him on the stand, we're not afraid of cross-examination.
Mr. Neal, he disputed, by several accounts, 6 to 12 prosecution witnesses today.
No, I don't remember that at all.
Marcy Leroff.
It's Marcy Leroff
Parents, four parents.
and Mr. Lydecker.
Four
The
parents.
parents and also the parents.
6 fire safety officers.
Oh, now you're a little bit wrong about the parents. As to the fire safety officers, he didn't purport to dispute the fire safety officers at all. He merely said that there were fire safety officers around when the 9:30 scene was being filmed involving the children.
They
Why
said
are
they
we
didn't
wrong
see
about
children.
the parents?
Oh,
Why are we wrong
well,
about
they're
the
wrong
parents?
about the parents because certainly Mr. Landis did tell the parents about the scene, what was going to happen. You'll hear more testimony on that.
They say that they weren't told about those factors like the helicopter.
My recollection is that there was some difference in the parents. You know, I don't. Andy, your recollection is sometimes good, and you may be right. But my recollection is that the parents were. There's some inconsistency between the parents about that. But in any event, Mr. Landis quite clearly and forcefully testified that he did tell the parents about the scene.
But Landis, how difficult a day was this for you personally, testifying for the first day of the trial?
I think that maybe for the moment, or as they say, for the nonce, let me do the talking. John's done enough.
Mr. Neal, do you see those differences as major differences?
What difference?
The differences between his testimony and the parents about being informed about the helicopter, the explosives, and all those things before they gave consent to their children to be involved.
I don't know how critical it is. You know, when you are responding to testimony, you respond to what that testimony has been. The parents, at least some of the parents, said they weren't told about the helicopter and the special effects. We have to respond to that. It'll be up to the jury to decide whether that's important. If so, how important. We simply have to tell you, and John simply has to tell you what he recollects and let the chips fall where they may.
Mr. Neal, will Mr. Landis' testimony make or break this case, in your view?
Oh, I think it's important for a person who's in Mr. Landis' circumstances to stand up and forthright tell you what he recollects. You know, I never know what makes and breaks the case. I think he's being a very fine witness. I don't know what makes and breaks a case. I don't even know that in view of the thin case that Mrs. DiAgostino has put on, whether it's really necessary for anybody to respond, but out of an abundance of caution, and because he wanted to tell his side of the story, Mr. Landis took the stand.
Jim,
Anything else?
Yeah, Jim, for 4.5 years there's been, a lot written and said and shown about this scene, and Mr. Landis really hasn't had a chance to respond. Today's really his first chance to respond to everything that's been written and said for the last 4.5 years. What's his response, his reaction to finally being able to tell his story publicly about what happened?
Can you answer that one question, maybe?
Answer that one.
Can we maybe get him to answer that one question?
I think not. Because with you all, I'm very used to you all. You all do a wonderful job. And one question leads to another question to another question. And that's what you should do. It's your job. The answer, what your question was?
His finally being able to give a public comment.
I'm tired too, I'll tell you.
After 4.5 years of everything that's been written and said about this, here's his chance. What's his reaction?
I think his reaction has to be mixed. I'll speak for him here. If he disagrees with me, maybe he'll say something. But I think it's very difficult to get up there under these circumstances. Nobody enjoys it. So on the one hand, I think it's an ordeal for him. Physically, emotionally, this was a tragedy to him too. On the other hand, I think Mr. Landis wanted this opportunity and has taken this opportunity to tell his side of the story. Is that okay with y'all?
One question, Ms. Landis, you've been through this for all these years too. Can you tell us how you feel about this thing finally coming to an end where he's able to tell his story?
I guess that she says that she doesn't really want to talk right now either. Thank you all very much.
Let him by.
Thank you for your courtesy.
Thank you. Yes, thank you all very much. Don't follow. Don't follow. Step up here if you will, please. Miss Leah. Step in the center. Leah.
Right here, please.
Let's just do the same thing. If everybody can back up and do it nicely.
Give her some room, folks.
Let's let the lady breathe, sir. Can you back up, please, so the cameras can keep over your shoulder?
Action.
That sounds like John Landis. It's a little premature.
Mr. D'Agostino, can you tell us, it appears as though the defense is going to try to have Mr. Landis refute a lot of the testimony of your witnesses. How do you react to that attack?
Well, he obviously has to try and do it because the testimony of these people is so devastating. But right now, just in his testimony today, I started counting how many people, if he's telling the truth so far, at least 19 other people are lying. And for what reason? What motive do all these other people have to come into a court of law and under oath fabricate a story? They have no vested stake in this case. Mr. Landis certainly does. Now, by the time he's done testifying tomorrow, I don't doubt but that at least another 10 people will have been proved to be liars based upon the testimony according to John Landis.
Elaborate on that. You mean the meetings?
Well, not only the meetings, but all the things that he indicated were said and done, and parents' knowledge, the fire safety officer's knowledge, Marcy Learoff, the whole world is lying according to John Landis, except John Landis. I find that somewhat incredible. And I'm assuming that the jurors will too.
Are those differences at this point very significant?
Well, the question is not whether the differences are significant. The question is, there is a jury instruction that if a witness is willfully false in one material part of his testimony, you should disregard the rest of his testimony unless you believe that, it's more likely that he's telling the truth or not. Now, if this man is on the witness stand right now basically calling everyone else a liar, I think you have to ask yourself, why did all these other people lie? For what possible purpose? They're not on trial.
So it would be surprising.
I beg your pardon?
Are you saying what he said can't be corroborated?
Who are you, sir?
Was somebody asking you a question?
I have a feeling you're not a camera operator. You're not a press person. You're a friend of Mr. Landis's. Why don't you just ask Mr. Landis those questions, sir?
I'm asking you.
I will speak with the press, sir.
Your impression, Leah, of what went on today. His attorney said he did very well under pressure.
Well, I don't think he was under pressure. I think he's operating with a very, very well-rehearsed and choreographed script. I think he's gone over this testimony many, 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 many times. I think as a director, he knows precisely what to do, when to appear to be hesitant, when to appear to be confident, when to appear to want to talk to the jury, etc., etc. I mean, he knows what he can get out of an actor, and he knows what performance he wants to get out of himself.
And he's achieving
it.
In your opportunity to cross-examine Mr. Landis, where will your focus be?
Or why don't you just wait until I start cross-examining him and you'll see.
You think you'll get to him tomorrow?
How will you be able to prove who is being accurate in this case?
The jury's going to have to decide that. If one person says one thing and 40 other people say something else, I think you sort of have to go along with the other 40.
Sure.
How did you contradict the fire safety officers?
Very simply, he indicated that on Wednesday they could see the children, and all 6 of them have indicated that they couldn't. That's just true.
I got it. Cut away.
I'm going to let you read.
Good luck, James.
Sometime or other it comes distant. You know what I'm saying? Damn near it is.
Lenny.
Yes, sir.
John.
And transfer.
Mr. Brown.
Yeah.
John.
You got something out of the president?
I think
he has something.
Is it gonna be in or out? Out.
What?
Not very auspicious.
What?
Gene, you had something outside first?
Who's out? Who's going to be out? Why?
Hey, John. John. Yes. Show me.
No, there were 2 cameras in 8. Let's take
Remain seated, come to order. Superior Court 132 is again in session. Quiet in the courtroom, please.
Jurors are not present. Is that all counsel? All the defendants are present. Mr. Brown?
Just one quick matter, Your Honor. I'm not asking for a decision at this point, but I wanted to bring it to the court's attention.
All right.
Your Honor cited to us earlier 1009.3.5 regarding jury instructions, which caused me to read 1009.3 and 1009.4. It seems to that to me, reading that those sections about the order of arguments, that it is not as clear as we all would assume that the people finish the argument. That if you look at 1009.3, the statute passed in 1872 refers to a situation under subsection E where the defendant argues the case. It obviously doesn't deal with a situation of multiple defendants, although it seems to talk about it as the preferred order. But then when you go to 1009-4, the legislature said that in the sound discretion of the court, that the order provided for in 1009-3 can be departed from. And the reason I'm bringing it to the court's attention at this point is it seems to me that depending on particularly what the rebuttal argument would be, that the court may want to consider exercising the discretion in 1009-4 and allowing the defense to argue once again for two reasons. One is if there's obviously, where you have multiple defendants, that the defense attorney who argues first doesn't have a chance to respond to either an argument or an inference from the defense attorney who argues before him, and that could be corrected by a final argument by the defense. And number two is if the prosecution should use the rebuttal not just to answer new things brought up by the defense, but in effect to just rehash the case over again, which I don't think is the purpose of rebuttal. I want to bring it to the court's attention that depending on what her rebuttal argument is, we may take the position and ask to argue once again, and I think it's clear there that the court has that discretion that has to be exercised, but I don't feel there's a predicate to exercise it at this point, but I think I should bring it to the court's attention at this point.
I was well aware that the court has discretion in that area, and especially in the area, however, of multiple defendants where there is a specific order that even has been decided among them for argument. It would appear to the court that there may be an occasion where the nature of the arguments are such and rise to such a level of conflict or raising of new issues that it might be appropriate before the people argue to have counsel get a chance to answer something that was not addressed in the people's opening argument especially. That has occurred to the court. It's not something that I would do lightly or perhaps even easily, but it's something that is obviously to be considered. All right, anything else?
One other item. Go ahead, Mr. Neal. Well, Your Honor, because I'll be prepared to start immediately after Mr. Sanders, and that may be before lunch, I have some charts here that I want to give Mrs. DiAgostino the opportunity to see. This is blow-up of certain testimony. I checked them. They are verbatim as I recollect, and they provide the transcript, nothing wrong.
All right. You may take an opportunity to look at them.
Thank you.
If they are accurate renditions of the transcript, the court would not be likely to exclude them.
Anything else I can do? Yeah.
Knowing that Mrs. DiAgostino has the final say in this case, Your Honor, they're right to the best of my ability.
I trust they are quite likely to be accurate in every respect.
There'll be no objection to me using those,
Not from the court. I hear nothing.
I don't have the transcript here, so I can't tell if it's taken out of context or not.
Yes, Mr.
One item, Your Honor. Last week during summation, Mrs. DiAgostino
combined the testimony of Gavin and Gamble as something against Dorsey Wingo, which was improper, because on page 24530, lines 10 through 12 or 13, she said he did not observe any of the procedural safeguards that Gavin or Gamble told you shouldn't have been done. Now, as I recall, and the record so reflects, as to John Gamble, she requested a limiting instruction, so it did not apply to Dorsey. So to lump his testimony with Gavin is improper. All of John Gamble's testimony that excluded Dorsey Wingo, right from the start, until he departed. And the record so reflects that, and I feel that was a misstatement and should be corrected on the record.
The objection's overruled.
I have one final thing, Your Honor. Mr. Levine, I believe, raised a strong objection last week to my commenting in my argument that Mr. Landis, any reference about Mr. Allingham not being told, I'm trying to recall what it was about the
stumble.
About the stumble, correct. And he stated that that approached Griffin error. That, in fact, is in the transcript. A question was specifically asked of Mr. Landis whether he had told Allingham that, and he indicated no, he had not.
Do you have a cite for that?
Checked that out this morning. Page 19665 in volume 94.
Thank you.
Your Honor, I assume it'll be all right to approach through the...
Yes, the counsel during argument may avail themselves of the well.
He's going to wear it back.
The record will reflect that all the jurors and all net jurors have been present. Good morning, everyone. All right, we will begin defense arguments now. Mr. Sanders, you may commence.
Thank you, Your Honor. May it please the court, ladies and gentlemen of the jury, I must tell you that I feel like it is a great and somewhat frightening responsibility to give you an adequate summation in a case that has gone on for over 8 months with almost 100 witnesses. A case in which the prosecution has taken 2.5 days just to open her summation. A case which includes the regrettable and inexcusable fact that John Landis intentionally violated the child labor law by hiring Renee, Chen, and Myca without the required permits, even though that's not the charge in this case, and that those children were killed during that employment. A case involving decisions, plans, and actions which, in hindsight, and only in hindsight, easily can be second-guessed by the Monday morning quarterbacks of this world. A case where our client is charged, is accused, with criminal responsibility for those awful deaths. As we face you now for the last time, those are the thoughts that nag at my mind, but I take great comfort in remembering that over 8 months ago, when my partner and I began talking to you and meeting with you during jury selection, that one important thing that we tried to do with each and every one of you was to bring out and discuss openly with you the awful facts that 3 human beings, 2 being little children, were killed and that John was responsible for having those children in that scene illegally, in violation of the child labor laws regarding hours, permits, and teacher labor representatives. We told you from the beginning that what John did was wrong, and that neither he nor we would try to excuse it, avoid it, or even minimize it. I know you remember that, and John told you that himself from the stand. I also know you remember, each of you, telling us that you would not let those things prejudice you or so affect you that you would be inclined to vote guilty just because he did that wrong, and just because 3 people were killed in this tragic accident. Further, I know that each of you knew then just how important those individual commitments were in the process of selecting only a fair and impartial jury. Now that the proof is in, I'm sure you have an even greater appreciation of the importance of those commitments in doing justice in this case. Because the prosecution took up an awful lot of time hammering on this illegal hiring, although it was never a disputed issue, and seeking to make it stretch beyond the truth by arguing that the reason for the violation was not to shoot after hours, to shoot at night, but because of safety. And in other words, that the prosecution's theory is that the defendants violated the labor laws in order that they could shoot this scene that they knew to be dangerous without any interference from the Labor Department. And further, because the prosecution would have you convict these defendants just because Renee, Chen, Myca Lee, and Vic Morrow did die in a mere movie scene, and under circumstances which certain people are willing to second guess on safety grounds, after 3 people have died, and with the blinding clarity of hindsight. Remember, she told you only last week, no movie is worth a life. Well, of course, that's not the issue in this case. As you know from the evidence, and you will know from the court's instructions later, neither of those is a legitimate, legal, or even fair basis for conviction of any of the charges in this case. Because the evidence presented to you, and under the court's instructions, will give you, as the law of this case, it is not permissible, it is not right, and it is not just to convict here just because John Landis, George Folsey, and Dan Allingham illegally hired the 2 children. The court will instruct you in an instruction entitled hiring, the second paragraph of a 2-paragraph instruction. In talking about these admissions as to the illegal hiring, the court will say to you, these admissions do not in themselves prove criminal negligence, and you may not convict defendants Landis, Folsey, or Allingham merely because of the violations which have been admitted. To convict, you must find beyond a reasonable doubt that these defendants acted with criminal negligence, as I have previously defined it, and that such negligence approximately caused the death. Moreover, it is not permissible, it is not right, and it is not just to convict in this case simply because 3 people died tragically. The court will instruct you as a part of the definition of the crimes in this case that are charged. That as a third element of each charge in the case, you must find that the defendant acted without due caution and circumspection. That is, the defendant acted with criminal negligence, as these terms will be defined hereinafter. And that in making that determination, you're not to judge the case based on the resultant harm, but upon the conduct proven to your satisfaction beyond a reasonable doubt of the defendants. Now that the proof is in, and you will soon be given the law to apply, it is even more important to separate the false issues and theories out from the truth before you, and to penetrate the smoke and see the facts clearly. Now that the proof is in, it is easier to do that and to focus on the truth of the matter. And 2.5 days of argument and all the nitpicking in the world cannot change that. What we shall do in our summation of the case is to focus on the truth of the matter, and it will not take us nearly as long as it took the prosecution. Mr. Neal and I will share the summation on behalf of Mr. Landis. I'll discuss the part of the case up until the week filming began at Indian Dunes. and thus deal with the charges in counts 2 and 4. And Mr. Neal will take everything thereafter, particularly the facts surrounding the accident and the charges in counts 1, 2, and 3. Now, in doing so, we will discuss some about the law and some about the facts. We're not going to discuss all the facts. There's no need to discuss all the facts. There's no need to stand up here for over 2 days and go over the facts with you. It is the genius of the American jury system that your collective memory and understanding of the facts is far better than any of the lawyers in the case. It is part of the genius of the American jury system that your collective judgment and your fairness is such that you cannot be fooled. Now, as we discuss the law, however, I want to remind you that the law is a province of the court. Now, we won't intend to invade that or mistake any part of the law, but if you think that something that I, Mr. Neal, said is different from what you hear from the court, you ignore what we say and follow the court's instructions. The same is true as to the facts. The facts are your problems. And obviously we won't intend to misstate anything, but if you think, based on your view of the evidence, that I say anything that is different from what you recollect the facts to be, then you disregard what I have said and go on what your memory and recollection and judgment is. I ask you to hold the prosecution to the same standard. Credit the lawyers in this case if and to the extent that those lawyers are backed up by the evidence. Hold us to what we say and hold her to what she says. We ask you that at the beginning, and we ask you that now. As you know, there are 5 separate charges in this case, and only Mr. Landis is charged in all 5 of these charges. And although each charge is different and must be considered by you separately, they all hinge on the same critical issue, in this case on the facts that you've heard. And that issue is criminal negligence. As I told you a moment ago, as a part of the definition of the offense charge, the court will tell you that the third element under any of these charges is criminal negligence. That is the key. Now, the prosecution has 2 alternatives as to Mr. Landis, but the ultimate issue still is whether Mr. Landis was guilty of criminal negligence under any of these charges. And criminal negligence, the court will define for you, and I'm not going to read you the entire instruction, but criminal negligence is the same thing as without due caution and circumspection, and involves negligent acts which are aggravated, reckless, wanton, and gross, and which are such a departure from what would be the conduct of an ordinarily prudent person or careful person under the same circumstances as to be contrary to or incompatible with a proper regard for human life. Accordingly, there is one main issue and one main truth in this case. That is whether Mr. John Landis believed that the scene was dangerous and acted in a reckless, wanton, or grossly negligent manner. Now, there are some other instructions that I would like to highlight just briefly. And by doing that, I don't mean to imply that these instructions are more important than other instructions or that you should ignore other instructions. I simply want to highlight a few. Another issue of importance in this case is the cause of the crash. Now, the prosecutor waited until her case in rebuttal to even broach this issue, and then she did it only with a single witness who, not surprisingly, came from the helicopter manufacturer and who assumed away the most important facts so that his opinion, whatever it is worth, is terribly misleading. But the issue has more importance than that. In the larger sense, it has importance because 3 people died. And the jury that is hearing the case involving those deaths is entitled to know what caused the crash and to be told the truth about it. It's also important, specifically in this case, because the charges here, as the court will instruct you, require a definite, unbroken connection between the conduct of those charged and the tragic accident itself. The court will give you an instruction on proximate cause. And in that instruction, the court will tell you that proximate cause is a cause which in natural and continuous sequence produces the death. and without which the death would not have occurred. The court will also tell you that the proximate cause and the conduct must be foreseeable, that great harm, death, would be foreseeable, and the court will define what foreseeable is. The court will also instruct you on superseding or intervening causes. That has to do with, if you find that there's more than one cause, how do you determine what is the proximate cause and what that means in the context of all the proof in this case. Now, there's another instruction that I want to speak about, and usually it's not an issue in a criminal case. That instruction has to do with the presumption of innocence and the burden of proof and what the burden of proof is. But Mrs. D'Agostino has made it necessary for me to talk about this a second or two, because she kept saying, why didn't the defense ask this? And why didn't the defense call this witness? And she started out so many phrases last week with, let's assume, let's assume. And then finally, to cap it all off, right at the very end of her argument, she read the reasonable doubt instruction to you and said basically, what this means is it's a decision you can live with. Ladies and gentlemen, that's not what that instruction says at all. What that instruction says is, in a criminal case, there is, with every person accused of a crime, a presumption of innocence. It's one of the bulwarks of our liberty. And because there is that presumption of innocence, the burden of proof in a criminal case always lies with the prosecution. That burden never shifts, it never goes away, it stays. It stays with the prosecution unless and until that is overcome by proof. And that proof must be proof beyond a reasonable doubt. And one of the best definitions in the world for reasonable doubt is proof that would convince you so that you would have an abiding conviction arising to a moral certainty of the truth of that proof. That's what reasonable doubt means. That's what the court will tell you. It is not simply a decision you can live with. It's much more important than that. Also, the court will instruct you, and this is the last instruction I intend to go into, as to circumstantial evidence in a case like this. And in essence, the court will tell you that where circumstantial evidence is involved, certainly it has to be involved in a case where criminal negligence is charged. If there's any proof at all, it has to be circumstantial. That circumstantial evidence, in order to convict, must be entirely consistent with the prosecution's theory and totally inconsistent with any other rational reason pointing to acquittal. And if you find that the circumstances point both ways equally, it would be your duty to accept and adopt those circumstances which point toward innocence. And it also tells you, this instruction, that if the circumstances point to one reasonable conclusion and also to an unreasonable conclusion, it will be your duty to adopt the reasonable conclusion, of course. Now, these are the principal instructions that guide us in focusing on the evidence in this case. Let us now turn to counts 2 and 4, the ones that are based upon the misdemeanors. Now, despite all the time that was spent on this part of the case, it really boils down to one clear-cut question, and that's a question that was posed and framed by the prosecution's theory. Remember what the prosecution said at the beginning of this case, and remember what the prosecution told you last week. The prosecution's theory is that the defendants, Landis, Folsey, and Allegheny, knew from the beginning, from day one, she said, that this scene that was going to be shot was going to be dangerous. Further, she contends that the decision to violate the law, the child labor laws, was made so that they could film this dangerous scene without any kind of safety interference from the Labor Department. In other words, the prosecution's theory as to counts 2 and 4 is that these labor law violations were not simply to film at night. Her theory seeks to stretch that into something else, that the violation was done because of safety considerations. We say, and John Landis testified before you for 4 days, that what the prosecution claims not only is false, but it is not backed up by any credible evidence. We say that there's only one reason for the violation, and that was to film at night. And that was bad, and that was wrong, but that's the only reason. Moreover, we say that John Landis never intended to expose Renee Chen or Myca Lee or anyone else to danger. Indeed, it never occurred to him that it would be dangerous at all to shoot this scene. This then is the real question under counts 2 and 4. This is the heart of the matter as to that theory. Now, to support these claims, the prosecution points to the testimony of Donna Schumann, Marcy Learoff, Cynthia Nye, and Anderson House. This is the testimony that must be analyzed and weighed and then believed if you are to credit the prosecution's theory. In this determination, you first must decide, does the evidence that you heard actually support this theory? And if it does, then you have to decide, is it credible? Is it believable? As to credibility, you will guide it first by the court's instruction on credibility. And I'm not going to read you that instruction, but the court is going to give you an instruction that's about a page long on judging credibility of witnesses. And also in making this determination, you will compare the testimony of these 4 witnesses with the testimony of John Landis, with Hillary Leach, with Ellie Cohn, with Alan Goldenhart, with Steve Larner, with Gary Kesselman, and several others. You will also, in making this determination, use your own good common sense and judgment. There's one thing else I would like to ask you to remember when you're making this determination. You remember in the opening statement, Mr. Neal said to you that in the aftermath of a tragedy like this, a terrible accident, it is almost inevitable that first, witnesses would honestly differ as to what happened, simply because of the nature of things, the nature of human beings. There would also be a second category, those people who would mix up what they really saw and heard with what they came to believe later on, or what they heard or read or supposed later on, so that what they came up with as a final judgment to give to you is what they wish they had said and done instead of what they actually said and did. And then there's a third category, the Monday morning quarterbacks, the second guessers, and then the fourth category, the witnesses who would lie. Now, for me, for us, it is a grave and hard thing to conclude that someone testified intentionally, falsely, under oath. We really don't like to believe that of anybody. Moreover, it is so very dangerous to our system of justice for people to get up on the stand, swear to tell the truth, and then not do it. It's not an accusation to be made or taken lightly. It should not be done without proof. But the sad and regrettable truth in this case is that certain people have lied. And what is even more sad and more regrettable is that what is really truly reprehensible is that the people who have lied are the cornerstone of the prosecution's theory. These are the key people that she relies upon in presenting this case to you. These are the people like Donna Schumann, Virginia Kearns, Steve Lydecker, Jack Tice. Let me give you an example. Remember Mr. Tice testified before you that he didn't know about the children that night. Now, never mind about Wednesday night and how long it took to shoot what has been called this dialogue scene. Never mind about where Mr. Tice was during all that filming. Forget that. Never mind about 9:30 and how long it took to shoot that scene. And that scene had an explosion on it. And you heard testimony that Mr. Tice radioed when the scene was to start and when it was to stop. Never mind about that. Remember what Mr. Tice told you happened right before the 220 shot. He testified that at about 2:10, he saw that Mr. Landis was about to put the operation into effect. The transcript page on this is 10,595. Check me on it. He said, I saw that Mr. Landis was about to put the operation into effect, and I went to Mr. Landis in the lagoon area. He's right around in here. I first talked to Mr. House. Mr. House ignored me. Then I talked to Mr. Landis and I asked him to stop. Hold on, because Mr. Hull was still eating chicken soup, and because I wanted to wait until he could get back up on the cliff. So Mr. Landis stopped, and they waited. Then Mr. Tice told you, remember now, Mr. Landis is getting ready to put the thing into operation. Mr. Tice then told you that after Mr. Hull was in place, and he so notified Mr. Landis, that he walked toward this area, and that he overheard Mr. Landis talking to Mr. Morrow. Remember? Where were the children? Where were the children? Well, you know from the testimony of Mr. Landis where the children were. You know from the testimony of Mr. Tice. He was about to put the scene in operation. The children were right here on the shore. And Mr. Landis told you that everything was ready to go. The children were on the shore with Mr. Morrow, and he was about to call the helicopter in, and Mr. Tice came up, and he said, wait. And he did, and they waited. All the while, the children are on that shoreline. No, Mr. Tice didn't see those children. Now, the fact that the key people in the prosecution's case have not testified truthfully, have lied, says an awful lot about the prosecution's case. It goes a long way toward explaining how a tragedy got transformed into a criminal prosecution. It goes a long way toward explaining why it took over 6 months for the prosecution to put on a case which he now tells you is plain and simple. And it tells you a lot about why it took over 2.5 days just to give the first part of her argument, and why she had to spend 75% of that time talking about our case. Let's start with Mrs. Schumann. Mrs. Schumann was the very first witness. She was advertised to you by Mrs. DiAgostino during her opening statement as the witness who would tell you that the concerns these defendants had concerned not just ours, but safety. She told you that. Check me on this too, page 5671 through 5672. She told you that in the opening statement. Now, of all the areas that we can discuss about Ms. Schumann, I'm going to limit myself to just 4. The first area is going to be the so-called going to jail statements that she claims that she heard from Mr. Landis and Mr. Folsey. You remember those statements. We spent a great deal of time on those. Now, as important as such statements would be to the prosecution of this case, and as partial as Mrs. Schumann was to the prosecution, my goodness, ladies and gentlemen of the jury, she was the Twilight Zone version of Watergate's Deep Throat. As partial as she was, it makes no sense. It makes no sense at all if this were true, that she did not testify to this at the grand jury in 1963, that she did not testify at the preliminary hearing in 1984, and it makes no sense that she wouldn't include them in this July the 11th letter to Mrs. DiAgostino that has 10 or 11 pages of attachment. Why, if it's true, why didn't it come up then? That in and of itself shows you that this testimony is absolutely incredible. But it gets worse. It gets much worse. When confronted during cross-examination on her first day on the stand, that was Thursday, September the 4th, she apparently realized from the cross-examination that it didn't really make any sense, that if those statements, she had really heard them, she hadn't testified to them about it before, included them in anything to Mrs. DiAgostino until late July of 1986. She realized it sounded incredible, so what did she say? She said, oh, I told the story earlier. I told these things earlier. And remember how it was that first on Thursday, September the 4th, she equivocated about who she told. The question was repeatedly asked, who did you tell? Who did you tell? I told millions of people. I told the guy over here, I told the woman over there, can't remember their name. Remember, she equivocated at first about who she told. And then finally, 3 or 4 pages later in the transcript, 5963, 5964, she said, she settles on Mr. Kesselman. She says, I told Mr. Kesselman, and that's at page 5967, she said that. That's Thursday, September 4th. On Monday, the next day of court, Monday afternoon, she's still on cross-examination. 3.5 days have passed, and she's learned, among other things, that Mr. Kesselman not only will not support this claim of hers that she just made, but that he had testified at a hearing outside your presence and sworn that she did not tell him these things. That's at page 6241. So what does she do next? She invents another story. This time she takes off after Mr. Kesselman. And she claims that Mr. Kesselman said to her, don't worry, I'll withhold these statements. I'll commit a crime. I'll violate the canons of ethics. I'll withhold these statements. And then she came up with the reason why. Remember the first reason on Monday, September the 8th? 2 reasons, really. So he wouldn't tip his hand. Remember that? Tip his hand, and so you wouldn't get, and her words were, the crap kicked out of it, end quote. Those were the 2 first reasons why she claimed that Mr. Kesselman said he would violate the law and withhold these statements. Then she had another night to think it over, and on redirect, on September the 9th, the next day, she came up with a whole new reason for why Mr. Kesselman said he would withhold it. You remember that reason? She said that he would withhold it to, quote, to give her a break, end quote, because it made her look bad if people knew what all she was saying about her supposed friend Mr. Folsey and Mr. Landis, if she was required to get up and say all these things in public. So she changed from millions of people to Mr. Kesselman to one reason to another reason. You will never see or hear a more striking and obvious development and evolution of a fabricated story as long as you live. A more clearly marked trail of patent lies. Actually, you do not even need to hear from John Landis or from Gary Kesselman to know that this tale is false, but you did. And you heard it from both of those witnesses convincingly and without dispute. And even Sergeant Buds, who wasn't the most impartial witness, having worked on this case for 4.5 years, even Sergeant Buds wouldn't back up Mrs. Schuman's claims with respect to this so-called Landis going to jail statement. Area number 2. Do you remember Mrs. Schuman testifying that she had some sort of a problem getting a script from the secretary, Alfred Campbell, that she went to Mr. Folsey and said, I can't get a script. And she claims Mr. Folsey said, well, there's a little problem. We're going to film or use children without a permit, quote, because of all the stuff and the explosives. Now, by the way, did you ever hear any other witness besides Mrs. Schuman testify in this case that they had any trouble getting the script? Did you ever hear Mrs. DiAgostino ask any other witness in this case if they had any trouble getting the script? Nope. Now there's one witness that I remember that she asked, Howard Sanders, who was a production assistant, a job he described as a gopher, that said he didn't have a script, but on cross-examination he said if I wanted one, I think I could have gotten one. So this business about not being able to get a script was kind of a short playing theater, wasn't it? Just for Mrs. Schuman. Nobody else, just for Mrs. Schuman. Now, no matter that this makes no sense, that around the time of the revision that included the children, and you have the exhibit with the date on it for that time. This is exhibit number 7. It is the script dated June 13th, 1982. Never mind that it makes no sense in the total context of things that the decision to go forward with the children without a permit was not made until the 1st of July. Excuse me, the first week of July. Never mind that out. And never mind the fact that when she testified before the preliminary hearing, as we pointed out on cross-examination, that the most important part of this statement, if you're believing the prosecution's theory about the explosions, she left that out at the preliminary hearing, only got improved by trial time. Never mind those things. You know that what she says is not true because she impeached herself. Remember, she testified that the first and only time that she ever saw Mr. Paul Stewart was when Mr. Landis interviewed Mr. Stewart for the job, and that was around the 1st of July. You remember that. And then later on, several pages later in the transcript, this is at page 5897, she was asked when she found out what was supposed to be involved in this scene. That is, when did you find out about the explosion and the helicopter and all this? When did you find that out? And her answer at 5897, she first learned about these things when she heard Mr. Landis and Mr. Stewart in Mr. Landis's office discussing this scene. Now, since that's the case, and that's what she said, how in the world can she be having this alleged conversation with Mr. Folsey around the middle of June when she doesn't even know about explosions until she hears Mr. Landis and Mr. Stewart in the 1st of July? Third area, the House memo, the Anderson House memo. This is a good example of how serious Mrs. Schumann takes her oath to tell the truth and how adaptable she is with the facts, depending on how she sees them. You remember she testified during direct examination that Anderson House wrote a memo and that she inadvertently discovered it in a pouch and read it. She didn't explain to you, she didn't qualify it, she didn't indicate any sort of uncertainty at all, did she? She said Anderson House wrote that memo. Well, after she left the stand, we discovered the truth. And then we're allowed to recall Ms. Schumann. Remember, she came back. And we asked her about this House memo. And she admitted on the stand that in truth and in fact, she had told Mr. Kesselman early on about this memo, that she didn't know who wrote it, that she thought it might be Richard Vane. But then later on, Mr. Kesselman calls her up and said, you were wrong. This memo was written by Anderson House. So on the basis of what Mr. Kesselman tells her, that he thinks is the truth, she gets up here and tells you without any sort of equivocation, without any explanation, without any uncertainty, that Anderson House did that. She had no more idea than the man in the moon who wrote that memo. But perhaps the most striking, and this is the last area for Ms. Schumann, the most striking contrast, which exemplifies Mrs. Schumann's credibility, is this. You remember during the opening statement, Mrs. DiAgostino told you that Mrs. Schumann would prove that these defendants were worried about the danger when they were violating the law, not about the hours. And she recited the statement that Donna Schumann claims she heard Mr. Folsey make. You remember the one. I asked Mr. Folsey what the penalty was for violating the law, the labor law. And Mr. Folsey said, a slap on the wrist, a little fine, unless they find out about the explosions or explosives, and then they will throw my butt in jail. When Mrs. DiAgostino recited that to you in the opening statement, she did it very gravely. She did it very seriously. Then Mrs. Schumann got on the stand, Thursday, September the 4th. Her first day of testimony, during her direct examination, she sat there and gave us all a chilling, chilling recital of this alleged Folsey statement. As she told it, and I know you remember this vividly, it was extremely serious and damning, as well as dramatic. You could have heard a pin drop. But then on Monday, September the 8th, she was confronted during cross-examination with the fact that it was utterly ridiculous for her to have heard such a statement from Mr. Folsey and not told her husband about it, because she and her husband were involved with helping to find the children to be in the scene. Indeed, Dr. Schumann was the man who actually located Myca Lee and Renee Chen. It would be absurd for her to have believed this statement from George Folsey. It would be absurd to believe that there was such a statement, and she didn't warn her husband. For goodness sakes, she should have said, Doctor, George Folsey just told me that he might get his butt thrown in jail, and I guess that means you might get your butt thrown in jail too. So when she was confronted with that, what did she do? she said, all of a sudden, she says, it's a joke. Oh, it was a joke. Now, she didn't tell you that was a joke on Thursday, September the 4th, and the prosecutor didn't tell you it was a joke when she gave her opening statement. And make no mistake about it, I'm not up here telling you it was a joke. It didn't happen. And the fact that she wiggled around from something that she thought would help the prosecution, got caught at it and went to it's a joke explanation, is proof that she lied about it, not proof that it was a joke. This was clear and obvious deceit on her part. She deceived 2 prosecutors, this court, and defense counsel, and worst of all, she tried to deceive you. And the only one who has let her get by with it, who will let her get by with it, is the prosecution. So much for Mrs. Schumann. Let's go to Marcy Leroff. Marcy Leroff, according to the prosecution, is important in this case purportedly because she claimed to have told John Landis and George Folsey that the Vietnamese rescue scene with the children was dangerous. And Mrs. DiAgostino argues to you that this was an early warning, June 16, 1982. This was an early warning that led the defendants to decide to violate the law so they could get by with filming a scene that was dangerous. Now, in the first place, it should be pointed out that Ms. Leroff did not actually say what Ms. DiAgostino said she would say in her opening statement. Look at page 56, 57 of the opening statement. Ms. DiAgostino said, Marcy Leroff will testify that she told Mr. Landis this was very dangerous. Instead, when Ms. Leroff testified, she said it sounded kind of dangerous. Second, it is virtually impossible to accept the premise of this theory that George Folsey, John Landis, would decide to violate the labor laws based on the comments of an assistant casting director with little movie experience and no experience with special effects explosions. But leave that aside for a moment and just consider the nature of Ms. Leroff's testimony as well as the surrounding facts and circumstances, and ask yourself 2 questions. 1, can we trust this as an accurate recollection? And 2, does it make sense? For Marcy Leroff is in that category of witnesses my partner told you about, the witnesses who would confuse things that she came up with after the fact with what actually happened during the course of these events, and that she would testify not to what actually was said and done, but what she wished she had said and done, or imagined had been said and done. Now, along that line, remember, Marcy Leroff was not even interviewed by the prosecution until almost a year after the accident, and over a year after this alleged meeting, June 16, 1982. She admits that she had read and heard a great deal about this case in that year before she was interviewed. And in her first recitation of what she said that Mr. Landis said in describing this new scene, she referred to the character Bill as Vic Morrow. We know, of course, that by June 16th, Vic Morrow wasn't even hired. He wasn't going to be, nobody knew he was going to be Bill at that time. And she kept saying that Vic Morrow would do this and Vic Morrow would do that. And then, in reciting the description of the scene, remember she said that Mr. Landis said that the soldiers would come to the hut and kick the door down and then chase Mr. Morrow and the children across the swamp. Now, obviously, Exhibit 7 and all the proof in this case tells you that was never the description of the scene. Doesn't have anything to do with the scene. But even more significantly, perhaps, she testified that Mr. Landis said on June 16, 1982, that the children would be filmed for 2 nights and that filming would start at 11 or 12 midnight and go till about 6 in the morning, and that the filming would be at the end of the schedule. You see what she's done? She's engrafted upon any legitimate memory of this meeting that she had certain things that she read about or heard about after the fact. The truth of the matter is, she couldn't have known on June 16th And John Landis couldn't have known on June 16th that Vic Morrow was going to be chosen to play the part of Bill. We know from the proof that it was always the plan until midnight, Wednesday, July the 21st, 1982. It was always the plan to film the children one night, not 2 nights. It's only after the accident that Miss Learoff discovered it was 2 nights. And how in the world anybody could have known on June 16th, 1982, that filming would start at 11 or 12 and end at 6 o'clock in the morning, particularly when you realize the decision, the budget decision by Warner Brothers to even include this scene wasn't made until the first week of July. That's 2 or 3 weeks later. And the decision to go forward with the children without the permits, without the welfare worker, was not made until after Warner Brothers had approved. Now, Exhibit 14. This is the shooting schedule for Twilight Zone Productions. This exhibit is dated July 2nd, 1982, and revised July 6th, 1982. Revised at the end of the first week of July, 1982. This is the shooting schedule wherein the scene involving the children and Vic Morrow and this rescue from the Vietnamese village is. You will also note that it is not at the end of the schedule. There are 2 or 3 days of shooting after that. It was at the end of the schedule, according to Ms. Learoff, because after the fact, she knew it was the end of the schedule. All you have to do to realize that she is mistaken in her recollections, that she is confused the after-the-fact facts with the before-the-fact facts, is to consider the testimony of Mr. Landis. First, in general, he told you that no one ever told him that this scene sounded dangerous to them at all. Second, he told you, and you remember this well, I'm sure, that this script, this revision, Exhibit number 7, which was the revision that put the Vietnamese village scene in and the 2 children. This was done on June 13th, the Sunday, not typed till the next day, Monday. But this was the result of a meeting with Terry Simmel and Lucy Fisher, Warner Brothers executives, who criticized. It was a legitimate criticism. Remembering that the burden of proof is on the prosecution. Remember also, this testimony by Mr. Landis is absolutely undisputed. It is not disputed by Terry Simmel. It is not disputed by Lucy Fisher. It is a fact, an uncontroverted fact in the evidence in this case. All right, second, Mr. Landis told you that because of his concern and maybe his enthusiasm for this change in the script, that he sent copies of the script to his casting director, Mr. Mike Fenton. And that at the next meeting, June the 16th, that he had with Mr. Fenton, he was interested in Mr. Fenton's reaction to the script, to the change. So he went through the whole scene, the new scene, with Mr. Fenton, and of course Ms. Learoff was there as the assistant to Mr. Fenton. Now when he went through the scene, apparently, according to Mr. Fenton's testimony, Mr. Fenton thought Mr. Landis was asking him to hire the 2 children. So Mr. Fenton's response when Mr. Landis went through the scene was to ask the question, and we now know why the meaning, the movie jargon behind this. He says, do they speak? Do they have speaking roles? In other words, he was asking them, are they extras or not? Mr. Landis said, no, they do not speak. Mr. Fenton, of course, doesn't hire extras, and that was the end of the matter. Now, none of the mechanics of this scene, how the scene was going to be shot, indeed whether it was going to be shot or not, included in the film, was not known, couldn't have been discussed, was not even known on June the 16th, 1982, at this meeting in which Ms. Learoff claims Mr. Landis says it sounded kind of dangerous. How do we know that? We have Mr. Landis' testimony that the decision by Warner Brothers to approve this new scene, this new budget, which involved building this village, it was not approved until the first week of July. And that until the first week of July, they were on hold as to whether they were either going to even have this new scene, and they certainly were on hold as to what they were going to do about hiring the children. And that in a meeting involving Frank Marshall, they were told that the budget had been approved, that they could go forward with this new scene, and then and only then there was a discussion about hiring the children and what should be done. And what did they do? The decision was made to call the Labor Department to determine if this scene could be done with a waiver. A call was made and the word came back, no, you can't shoot after dark. In essence, you can't shoot after dark with children this age. Now, ladies and gentlemen of the jury, did the prosecution call Kathleen Kennedy to dispute this? Did the prosecution call Frank Marshall to dispute this? No. This testimony, this evidence as to what happened is undisputed in this case. It is uncontroverted. And when you consider what was going on, consider the exhibits, the dates on the shooting schedule, the dates on the script. What Ms. Luroff says makes no sense at all. Therefore, as John Landis testified, not only was there no mention of danger in this brief discussion, there clearly was no basis for any such comment because it was not known how or when or if these scenes would be filmed on June 16, 1982. And moreover, Mr. Landis added that if something like that had been said by either Mr. Fenton or Ms. Luroff or any other casting person, he believes he would have remembered it for two reasons. One is he does remember the meeting, and second, it would be extraordinary and therefore memorable for any casting director to volunteer such a comment, particularly in this instance. Another question: why, from the prosecution having the burden of proof, why did the prosecution not ask Mr. Fenton when he came up here to the stand and rebuttal? Why did she not ask the most important question? What's important about this conversation that Mrs. Luroff thinks she now remembers? What's important about it? Is it important whether Mr. Landis was interpreted by Mr. Fenton as asking them to hire? The hiring, is that important? No, it's not important. What's important about this conversation is the comment, it sounded kind of dangerous. That's what's supposed to be important about Ms. Luroff's testimony. That's what's supposed to fit the theory of the prosecution. And she didn't even ask Mr. Fenton about that comment. And you know why. And you know why. What she did do is she trotted up there to that little list and she wrote Mr. Fenton's name down on there to try to deceive you into thinking that Mr. Fenton somehow corroborated Ms. Luroff. But it won't work. You know the facts. So as to Ms. Luroff, the evidence shows you that her recollection is faulty, that she has confused things after the fact with things that actually happened. Her testimony shows you that what she says happened simply doesn't make any sense in light of the objective facts in the case. All right, let's turn to Anderson House and Cynthia Nye. Luckily, we can discuss these together because they fall into the same category. Because even if you credit the testimony of these two witnesses fully, the fact of the matter is they do not say what Mrs. DiAgostino claims that they said. They do not say anything that supports this theory of hers. Cynthia Nye's first. Cynthia Nye testified that she overheard Mr. Folsey say, "We're all going to jail." That he did this in a hallway as he was leaving a meeting. Mrs. DiAgostino says this proves that the defendants knew about danger. Now, the actual proof is that Ms. Nye did not claim that she heard Mr. Landis say anything. She did not testify that Mr. Landis heard Mr. Folsey say anything. But perhaps even more importantly, she does not testify as to what the predicate was for this comment. We don't know what the conversation was before this comment. We don't know who was involved in the conversation. We don't know what they're talking about. So what she's got is a out-of-the-blue statement rooted in nothing in the evidence, which she asks you to fit into her theory. What she's doing is trying to stretch the truth beyond what can be done. She's taking the statement out of the blue and asking you to root it in some sort of evidence that is not there. The truth of the matter is that even if you could accept this first leap, that this was somehow tied to the children hiring, although you have no evidence that that statement reflects on that at all, you certainly can't take the next leap, and that is it reflects danger. Anderson House, same category. Mrs. DiAgostino told you that Anderson House repeatedly warned the defendants of danger. Remember, she said that more than once. He repeatedly warned of danger. What's the truth? Anderson House testified to 4 conversations. 3 of them on the telephone with Mr. Allingham, and 1 of them on the set with Mr. Cohen, Mr. Landis. The first call, Mr. House testified, and this is at page 10,279 to 10,280, that the first call to Mr. Allingham only involved the question, is this going to be night for night? In other words, you're going to shoot this at night? And the answer was yes. And that's all that was involved in the first conversation. Not a word about danger. The second conversation, the second call, and this is at page 10,282. 10,284, 10,286, and 10,368. When he called Mr. Allingham, he testified before you that he, Mr. House, didn't know because of inexperience. He didn't know whether this scene was going to be dangerous or not. He simply had no experience with special effects. He didn't know. So he asked. He made an inquiry of Mr. Allingham. He didn't warn him. He simply asked, is this going to be dangerous? And Mr. Allingham responded, this scene could and would be done safely. That's not a warning. That's a question. The third call, he testified that danger was not even mentioned at all. This was simply a discussion asking if he could get Mr. Landis to look at some midgets or stunt doubles. There was no conversation about danger. The only conversation had to do with the illegality of shooting children at night. The same is true for the last conversation with Mr. Cohen and Mr. Landis. That's at pages 10,374 to 10,375. That it did not involve danger, nothing was said about danger, and that the conversation involved only illegality. So therefore, as to both of these witnesses, Ms. Nye, Mr. House, you don't have to even get to the credibility question because they do not prove this theory of the prosecution. They prove, if anything, that which we never disputed, and that is that John Landis was involved in violating the labor law by seeking to film children after hours without a teacher labor representative. Now, to be sure, there is other evidence in this record that other people did do some things to cover it up, as they say, and that these things that they did were rather sketchy and inconsistent and downright silly. But this proof all falls into the same category. It is certainly proof that a violation of the law was committed, not disputed. But it does not prove anything about danger or that anybody knew anything about danger because there's not a single shred of evidence to make that connection. So therefore, the call sheets, the cash vouchers, the cash payments, the radio security, the testimony of people like Richard Vane, Hillary Leach, those kinds of, that testimony, it falls in the same category. It proves only that which we don't dispute. It does not and cannot be stretched to prove this theory that the prosecution had. There is no basis in fact, ladies and gentlemen of the jury, for saying that the defendants ever thought this scene would be dangerous or that anyone told them that. There's certainly no basis in the evidence that this was the reason or even a reason for the violation of law in this case. Now, there's some other witnesses that I feel I ought to mention, mainly because of this cute little list that the prosecution put up here, these 24 names. She started out that list with Miss Julie Hua, Mr. Jeff Powell. And you talk about your major conflicts in testimony. She claims that Mr. Landis, according to Mr. Landis, that these people are lying because of the number of people that were supposed to be at Franklin Canyon. One says 6, the other says 3. Now that's a big difference. That's a reason to have somebody say they're a liar. That's a reason to accuse somebody of lying. And Mrs. Hua, of course, testified to only part of what John Landis remembered. He told Mrs. Hua and her family about the scene, but she did remember part. Now that brings up another point. Mrs. DiAgostino suggested to you that I and some other lawyers went to see Mrs. Hua a couple of nights before her testimony, and she wants you to infer that we did something wrong, that we suggested something to Ms. Hua. I resent that. If you'll remember, I went to see Mr. Jackie Cooper a couple of days before his testimony, too. But I'll tell you one thing Ms. Hua didn't get up here and say. She didn't get up here and say that Mr. Jim Sanders came to my house and we went into a room and Mr. Sanders closed the door and said to me, Ms. Hua, you're not important. And I'm not important. Only this case is important. You didn't hear anything like that from Ms. Hua. Ladies and gentlemen of the jury, John Landis doesn't say that Ms. Hua lied. John Landis doesn't say that Jeff Powell lied because of the number of people. And that brings us to the parents. Mrs. DiAgostino wants you to believe that John Landis says the parents are lying. There's not a single person in this courtroom that thinks there's any sort of defense to these charges, that these parents knew about the no permits and knew the specifics of this scene. And there's not a single person in this courtroom that would ever think for a moment, after what John Landis has gone through as a result of this accident, that John Landis would say that those parents and what they've gone through would be lying. That's absurd. The point is, we're not asking you, John Landis is not asking you, nobody in this courtroom is asking you to judge the conduct of the parents. Of course not. What's important is not what the parents knew or remember about what all that was told and what they appreciate about the scene. That's not important. Nobody's trying to blame the parents. What's important is judging the actions of the defendants. Did they attempt to mislead the parents? Did they tell them lies? The proof tells you no. The proof tells you no, they didn't. That's what's important. Don't get caught trapped, Ms. DiAgostino would ask you to get into, of trying to blame the parents. Now, one other witness, Colleen Logan. Mrs. DiAgostino tells you this witness is important because Colleen Logan tells you that you could have gotten a waiver till 10 o'clock at night. She testified to that on the witness stand. They could have gotten a waiver. And if they had have tried to get a waiver, they would have had to say certain things. And those things would have been considered by us, such as the explosions, the helicopter, the scene, etc. Now, the problem with Mrs. Logan's testimony is, what proof do you have that the defendants knew what Mrs. Logan claims she knows? What proof do you have that any one of these gentlemen knew that you could get a waiver till 10 o'clock? None. Absolutely none. What proof do you have to the contrary? Well, first you got Mr. Landis' call, or the call made at the behest of Frank Marshall, first week of July, trying to find out about it. And that tells you a lot. That call tells you an awful lot about this case. It tells you a lot about her theory, too. If her theory is right, why are they calling? Doesn't make sense, does it? Because her theory doesn't make sense. Second, you know from exhibit number 18 that what the book says about permits and waivers is that for children 6 and 7 years old, and we passed this book around to you when Ms. Logan was on the stand, for children 6 and 7 years old, you can't get a waiver. 6:30. 6:30 is the latest you can get. That's what the book says. And Ms. Logan further testified that if someone simply calls in to ask a question like this, the answer they would be given by her staff is what is in the book. In other words, it absolutely corroborates what the call by Frank Marshall was in the first week of July. You can't get a waiver for children this age. That's what the book says. If you accept the prosecution's theory, you have to ignore the book, the language of the book. You even have to ignore Mr. Jackie Cooper. Even Jackie Cooper got up here and testified that he admitted to me that he thought in July of 1982 that the latest you could ever get filming of children this age was 8 o'clock. You remember that. Now, if Jackie Cooper, not the most impartial witness in the world, if Jackie Cooper testified 8 o'clock was what he thought, how in the world can you assume that these gentlemen, without any evidence whatsoever, knew it was 10 o'clock? It's just not true. So what you're back to is Donna Schumann and Marcy Learoff. That's the key to this prosecution's theory about counts 2 and 4. And what you have is a question of whether you believe Marcy Learoff gave any sort of a warning to Mr. Landis and Mr. Foley by allegedly saying it sounded kind of dangerous over the testimony of John Landis. 2, the undisputed factual context, which is at odds with her. 3, the exhibits in the record. 4, your own common sense. And 5, in spite of the failure of the prosecution to corroborate this danger statement with Mike Fenton. Donna Schumann, key to deciding this theory of the case. And of course, I know you know by now that this is not the main issue in the case. This is the theory of the prosecution. The main issue is criminal negligence. But on this theory, in order to credit it, you have to believe the testimony of Ms. Donna Schumann over the testimony of John Landis, the testimony of Gary Kesselman, the testimony of Sergeant Budd, the testimony of Hillary Leach, the testimony of Anderson House, Ellie Cohen, Steve Warner, Alan Goldenhar, the testimony of all the special effects people, the testimony of the fire safety officers. You have to believe it over what you saw Ms. Schumann do on the stand. And you have to believe it over your own common sense. I submit to you, ladies and gentlemen of the jury, respectfully and sincerely, that the evidence discredits this pair and proves to you the truth of what John Landis told you. But it is even easier than that. Remember, because this is a criminal case, the jury does not simply decide if the prosecution witnesses are more believable than not. No, the standard is much higher. And before you can even get to first base in accepting the prosecution's theory on counts 2 and 4, you must believe Donna Schumann and Marcy Learoff over all the evidence beyond a reasonable doubt. You must be convinced of these 2 prosecution witnesses to the extent that you have an abiding conviction amounting to a moral certainty of the truth of what they have said. This simply cannot be. And I know what you will do with this testimony of these 2 women and what you will do with the prosecution's theory. I leave it to your judgment. I leave it in your hands. Now my partner will discuss the main issue, the ultimate issue in this case.
Mr. Neal?
May it please the court, counsel, ladies and gentlemen of the jury.
Many months ago, I stood before you in an opening statement, and I said that a tragic accident occurred on July 23, 1982. Not one of these defendants intended to hurt anyone. Not one of these defendants thought the accident scene, as planned and rehearsed, was dangerous. Not one of these defendants is guilty of reckless and wanton conduct. Not one of these defendants is a criminal. Many months ago, in that same opening statement, I outlined the plan for the 220 scene. I went over in some detail the full rehearsal of that plan. And then I listed one by one the unforeseen and unforeseeable events that caused this tragic accident. I mentioned the opening statement because Mrs. DeAugustino made one and I made one. And in that opening statement and in those opening statements, we made promises to you about what the proof would show. You have the right to hold each of us to our promises, and I'm here now to redeem mine in whatever time it takes, and for which I apologize. Mrs. DeAugustino, as Mr. Sanders said, spent 2.5 days up here talking to you. I was struck by the fact that for 2 of those days, she talked about the defendant's case and what we were going to say when we got up here. And she spent 1/2 of a day talking about her case. I was a prosecutor for many years, and I recognize that as an old trick of prosecutors. When you recognize that the defense is strong and it's going to be put to you later on, what do? Well, you get up here and you talk about it and you say, oh, you listen to them when they come up, they're going to tell you this and that and this, and of course we'll get up here and tell you this and that and the other, because it's the truth. The reason the prosecutor gets up here and spends 2 days talking about our defense and 1 day talking about her case is the old trick of if you've got something that hurts you, if you know your opponent's defense is strong, talk about it. Try to take some of the force out of it. You know, it's an old gambit that if you put a witness on the stand and you know he's going to say something that you'd rather not have happened, you don't wait for the prosecutor or the opponent to bring it up in cross-examination. You bring it out yourself on direct to minimize the force of it. So the reason Mrs. DeAugustino spent 2 days up here on the defendant's case and 1/2 a day on her case, for which she has the burden of proof, is that she knows the strength of our case. Now, one thing Mrs. DeAugustino said, that we would get up here and that we would blow smoke, that we would try to blow smoke on you and confuse you. We'll see who blows smoke. I resent the charge, as Mr. Sanders does, and I'll tell you what I'll do. As I go through my summation, when I think that there may be some question of what was said, I'll give you the transcript pages. And if you want to take them down, you take them down, and then you check me on it.
May we approach the bench, Your Honor, please? Objection.
No.
Later in this summation, I will get to what those 3 categories that Mrs. DeAugustino said our case, our defense, fell into. Some sort of cutesy things like soddy, red herring, and B-double-E. I do think that defense counsel and the prosecutor has an obligation to try to help you, to try to help us understand. A case that goes this long is not easy to remember. It's not easy to understand. It's not easy to put together. You know, sometimes I am absolutely amazed at what we expect juries in this country to do. You know, we study all these transcripts at night. We review them at the end of the day after a witness has testified, or the next day when we get them. We have studied the case in advance of the trial, and so we should know what the proof is. And you know what we expect the jury to do? A jury comes in, you're not supposed to have known or remember anything about the case. You're supposed to sit there and listen, and then at the end of the day, unlike us, you're not supposed to talk about the case, and then we go 8 or 9 months of detailed testimony, and we ask you to remember. We have a job to help you. And I hope that when I get here and I get through here, whether you agree with me or not, you will say to me, well, Mr. Neal tried to help me understand the case. If I do that, I'll be satisfied with my remarks. And let me tell you something right now. The way I'm going to try to help us and to me, because I get confused sometimes about the case myself, the way I'm going to start trying to help all of us understand is to tell you what I think the real issues are in this case. The issues you must decide, for us or against, to decide this case. I think there are 3. I think number 1, did Mr. Landis and these defendants, reasonably believe that the plan for the 220 scene was safe? Did Mr. Landis and the defendants reasonably believe that the plan for the 220 scene was safe? Number 2, was that plan adequately and well rehearsed? And number 3, did unforeseen and unforeseeable events intervene to cause this tragic accident? I submit to you that you can talk about Saudis and bees and hearings all you want to, but the relevant proof will address itself to those issues. And I propose to meet them head on. But when you're talking about issues, you've got to talk just a moment about the law, because the law is kind of the guide as to how you assess and weigh the evidence. And the court gives that to you, and I will mention only 2 or 3 things. As Mr. Sanders says, and I repeat it, in fact, for that I apologize, the pivotal issue, the central issue in this case, and unlike Mrs. DeAugustino's charts where she puts 2 and 4 and she doesn't include criminal negligence, I tell you, and the court will tell you, whether the defendants were guilty of criminal negligence beyond a reasonable doubt applies to all 5 counts and is the pivotal issue. And criminal negligence is far more than negligence. Negligence is acting unreasonably. And when you act unreasonably, then you get sued for money damages. Criminal negligence is far more than that. Criminal negligence is acts that are aggravated, reckless, wanton, and gross, amounting to an indifference or a disregard of human life. The second thing you will get to, the second thing that you have to concern is foreseeability and intervening causes. And I'm going to read my one and only instruction to you that I will do in all my summation. You will have the court read his instructions to you on the law. I believe it is true that you will get a copy, a written copy of those instructions to take back with you, and you can read them as well as I can, and perhaps better. But I'm going to read one to you. And I'm going to read one to you simply to show you what happened when Mrs. DeAugustino was up here.
she read a portion of one. Let me read you one, tell you where she stopped, and then read the rest of it. Intervening causes. She read this portion. Quote, if you find that the conduct of some third person intervened so as to be a cause of the victim's death, the conduct of that person will not relieve the defendant of criminal responsibility for the deaths if the third person's conduct was a normal and reasonably foreseeable result of the defendant's criminal negligence. Mrs. DeAugustino stopped right there. Strange, but maybe not so strange. Let me continue. However, if the third person's conduct was not reasonably foreseeable, the defendant will be relieved of criminal responsibility for the victim's death. A defendant has a duty to anticipate the common and ordinary consequences of his own acts, and he is liable for those consequences. However, he is not criminally liable for extraordinary and abnormal occurrences which are not reasonably foreseeable as a consequence of his own conduct. Now, unlike Mrs. DeAugustino, that is the entire instruction. You are to judge my client and the others, not by hindsight. You are not to look at the consequences and look backwards. And finally, as Mr. Sanders says, to convict anyone, the prosecutor must prove that him, any one of them, guilty beyond a reasonable doubt to a moral certainty.
Would this be a good time to go into recess?
Anytime.
We'll be in recess until 1:30 p.m. The jurors are reminded of the admonition. 1:30 p.m.
Your Honor.
I just stay up here.
Close out the jurors, please.
That's all right. I should have saved some time to walk back over here. But in the court, if I put this exhibit 500 up right there,
That's fine.
when I get to it.
As long as there's no objection from other defense counsel who'll be behind it. I'm familiar with it enough that I don't have a problem with seeing only the back of the exhibit, but if other counsel do, then we'll have to work something out, or they can move to another vantage point and block the spectators.
I can see the back of Mr. Neal, I can see the back of the exhibit.
See the bald spots, that's what bothers me.
No comment.
No offense to the court.
All the jurors and alternate jurors are again present. Mr. Neal, you may continue with your argument.
Thank you, Your Honor. Members of the jury, I have not mentioned the children to this point for 2 or 3 reasons. One, Mr. Sanders addressed that issue. 2, and I would emphasize this, the scene as planned was safe for Mr. Morrow and the children, or it was not safe for either. The children took no independent action and made no independent judgment, and they were not killed because they were children, any more than Mr. Morrow was killed because he was an adult. Finally, as Mr. Sanders told you, the same criminal negligence, reckless and wanton conduct applies to both Mr. Morrow and the children. Before I proceed further, everybody has thanked the jury. When I agreed to come out and represent Mr. Landis, some of my friends back home said to me, "Why are you going out there?
Objection, Your Honor.
any event. I recognized when I came out here that people were the same all over. If you're fair to them, they'll be fair to you. And I appreciate your fairness and your courtesy to me. Let me move on to what Mr. Sanders said I would cover, and that is the period at Indian Dunes. I think I can maybe save some time by putting up this diagram right here where I can point to it without having to walk up there and back. So I trust that everyone now can see at least this portion over here, the village area where we'll talk about. Indian Dunes was selected as the area in which to film the Vietnamese segment of the Twilight Zone. Mrs. D'Agostino said to you something about this being a tight area. If it is a tight area, then somebody should tell Hollywood itself, because as you have heard, many, many, many movies were made there with special effects and helicopters. Mr. Gavin, prosecution witness, said that he had flown through fireballs there with a helicopter. Mr. Gamble, prosecution witness Gamble, told you that he had been involved in many movies with special effects and helicopters at the Twilight Zone. Mr. McKernan has flown helicopter at Indian Dunes that involve special effects and actors in the same scene. And they went there to film the Vietnamese segment of the Twilight Zone. With that history, one must ask himself or herself, well, then was it reckless conduct for Mr. Landis to approve Indian Dunes as the area in which to film that segment? And while we're on that now, let's talk about what was done. First, they obtained a permit to film, obtained a permit from the Los Angeles County Fire Department. This is exhibit number 31, and it points out that there will be helicopters, tanks, gasoline explosives, vehicles, gunfire, squibs, smoke effects. That's exhibit 31, and you can look at it. With that permit came 6 fire safety officers out there at the scene during the filming of this segment of the Twilight Zone. At least they were there for Wednesday and Thursday nights that I will talk about. Those fire safety officers testified that they knew there would be special effects explosives, knew that there'd be burning sawdust, and they knew that the fireballs would go at least 100 feet in the air. Indeed, as you heard one of them testify, it was Mr. Stewart who insisted, with the approval of the production people, that they have 6 fire safety officers there. It's my recollection of the evidence that the fire safety men says, well, we don't have to have that many fire safety officers. We can use some of your special effects people to substitute as fire safety officers. And Mr. Stewart said, no, even though it's more expensive, let's have 6 fire safety officers there. Was that reckless conduct? Now, the fire safety officers during this period of time were located 4 up on this cliff I'm pointing to now in exhibit up here, Exhibit 500 on the cliff. 4 fire safety officers up there and 2 in and around the village area. The 2 down here were Mr. Jack Tice and Mr. Rimmer. It was Mr. Rimmer's and Mr. Tice's job to supervise the special effects on the ground and see that they were safe. That's transcript pages 11,642 to 643 and 11,503. Mr. Hull testified, he was the head fire safety officer, that fire safety officers have the authority to tell the director if they think it's unsafe or if they think the special effects are too close to the helicopter and to shut the set down. Mr. Hull and the other fire safety officers testified that they have the responsibility for safety on the set, including the use of special effects, and that's 11,795. Prosecution witness Morgan, a fire safety supervisor, testified that the job of a fire safety officer is to make sure no one is injured from special effects on a movie set. So they had the scene. They got the area, they built the village, they selected Indian Dunes because many, many movies were made there. They declined an offer to be less expensive and take fewer fire safety officers. They got the whole 6 fire safety officers, and now they are in business. Another thing that happened was they selected Mr. Stewart, Mr. Paul Stewart, as the foreman of special effects. You heard Mr. Merriweather testify that Mr. Stewart, by reputation, was the best in the business, and that has not been contradicted. Mr. Stewart then got other special effects experts, 4 of them, Mr. Quibell, Mr. Jerry Williams, Mr. Harry Stewart, and Mr. Chamomile, yes. And 2 of these people, Mr. Chamomile and Mr. Stewart, had held the highest powder cards the state of California issued, #1 powder card. Now, was it reckless to select the man who was the best special effects expert in the business, according to Mr. Merriweather? And then they needed a helicopter pilot. And so they selected, or Mr. Landis approved the selection of Mr. Dorsey Wingo. And you heard of his qualifications. 4,500 hours in a helicopter, principally this Huey helicopter, almost 1,000 hours in combat in Vietnam, 1,200 hours fighting forest fires, and he's also skilled in handling pyrotechnics in the entertainment industry. A man extremely well qualified. That sets the stage then for Wednesday night and Thursday night, July 21 and July 22, 1982. On Wednesday night, as you'll remember, it was intended that they would film the entire scene that evening, on Wednesday evening, July 21, 1982. And very significant here, ladies and gentlemen, it is without dispute that Mr. Landis had his wife there. And he assumed that they would be filming what turned out to be the accident scene with his wife right there. Mr. Foles' wife and children were there on the evening of July 21, 1982, and he assumed they'd be completing the entire filming, including what turned out to be the accident scene. Would they have had their wives and their children there if they thought the scene was dangerous? How much more telling evidence can you really get? And Mrs. DeAugustino, one of the things she said to you was that there were a lack of meetings, or insufficient number of meetings, or no meetings where the scene was planned. Let me hit that right now. Mr. Roger Smith testified that as to meetings, on Wednesday, July 21, 1982, there was a meeting where Mr. Landis was telling us generally what was going to happen. Transcript page 15,195. Mr. Scott testified he was present at a meeting on Wednesday evening at which all department heads were present with Mr. Landis to discuss upcoming shots. Mr. McClarty testified of a meeting on Thursday evening involving the accident scene, and present were at least Mr. Landis, Mr. McClarty, Mr. Indoso, Mr. Stewart, Mr. Allenham, Mr. Cohn, the first assistant, and Mr. Wingo. He also said Mr. Landis was using a stick and drawing a diagram. Mr. Indoso, prosecution witness Indoso, as these others, testified of meetings before the accident scene when Mr. Landis was drawing a diagram in the dirt as to what the plan was. Mr. Cohn testified there was a practice of having meetings among Landis himself and the department heads before each scene was shot. Prosecution witness Cohn. That's transcript page 10,607. He also said there were constant meetings from 11:30 through lunch, through the rehearsal to 2:20, and that's transcript page 10,795. Mr. House, prosecution witness House even, testified there were rehearsals before every scene and there were many meetings. Mr. Wingo, of course, detailed the many briefings that occurred, a briefing, at least one, before each scene was filmed. Mr. Larner, the director of photography, testified there were meetings and setups with Mr. Landis before each filming, and Mr. Landis would describe what was going to be filmed and how. That's transcript pages 23,284 to 23,286. Mr. Landis, of course, also testified to you about the meetings and the rehearsals before each scene. On Wednesday evening, then, my recollection is they got there, they gathered about 6:30 in the evening. And you heard the testimony from Mr. Landis that first he had a meeting with Mr. Wingo, Mr. Stewart, and Mr. Coleman. And he described what was going to be shot that night. And the scenes to be shot, basically at Indian Dunes, were the dolly scene. And I'll talk about that just in a minute. And then what we've referred to as the dialogue scene. And then what we've come to know as the 9:30 scene, the 11:30 scene, and the 2:20 scene. And during this evening, Wednesday evening, July 21, 1982, Mr. Landis asked Mr. Stewart if it was all right to put a mortar in the huts back here, and I am referring now to the left rear side of the village as you look at 500. Mr. Stewart says no. These have metal roofs, and it might not be safe. And you know what Mr. Landis says? He says, okay, fine. We won't do it. Does that sound like reckless conduct? During that evening, then, Mr. Wingo got in his helicopter and flew his reconnaissance flights all over the area to familiarize himself with the area and with Indian Dunes. And then what they did then was start filming. First, they had the dolly shot. And the dolly shot, as you remember, according to the script, Mr. Morrow had been in occupied France, and he was shot there, and he'd been in the South in the 50s, and he'd been shot by the Ku Klux Klan, and he now finds himself in the Vietnamese village. He's shot in the arm, he's shot in the leg, and he limps up the shore here then, and there's a dolly. And what took so long was there is a dolly on tracks here that had been built to follow Mr. Morrow, limping, wounded badly, coming up into the village, and then collapsing between the third or the second hut from the right, I don't remember which one, and he falls asleep. That's the dolly scene. It took a long time to shoot, and basically that was him with the camera on dolly following him up there. Then comes what would have been referred to as the dialogue scene. That scene then, it picks up where Mr. Morrow is asleep, and he wakes up and he sees the two Vietnamese children, and he tries to talk to them. And one of the humorous lines was he asks them about if they have any food, and they can't answer because they don't understand what he's saying. And then he says, well, I guess you don't have any beer then. And then they hear the sound of a helicopter coming. And the children then run into this, I guess it's the third hut from the right, or the second hut to the right. They run in that hut to hide. And that sets the stage then for what comes later. Now it took a long time to complete these scenes, to film what I've referred to as the dolly scene and the dialogue scene. And of course in the dialogue scene you've heard the testimony that they rehearsed it several times. Of course the children were in this. Now none of the 6 fire safety officers, including Mr. Tice and Mr. Rimmer, who were in the village area, said they saw the children on Wednesday evening. When they finish then the dolly and the dialogue scene, it's getting about midnight. And Mr. Cone comes up, the first assistant, comes up to Mr. Landis and says, look, let's don't rush. If we tried to complete the scene tonight, we'd have to rush. Let's don't rush. Let's just shoot one more night. And Mr. Landis says, okay. Now, does that sound like reckless conduct? It's funny, Mrs. DeAugustino turns that decision not to rush and go one more night. She turns it around and says, aha, they were behind schedule and rushing. Well, they got one night behind schedule deliberately because they didn't want to rush. Now then, that concludes Wednesday night, July 21, 1982. And to my recollection, there is no dispute about what happened there. Thursday night then comes. And the first shot on Thursday night is to be what we've referred to as the 9:30 shot. You've heard the testimony that they were shooting these on that night out of sequence. In any event, Mr. Landis then has a meeting with Mr. Stewart, Mr. Wingo, Mr. Cohn, and Mr. Larner, and he describes the 9:30 scene. The 9:30 scene then is the scene with the children in the hut. There is the sound of the helicopter. Mr. Morrow runs in, takes the two children, runs back out, and then there's an explosion back off behind the hut, and there's another explosion there. That's what Mr. Landis describes. And let's talk about those explosives a minute. There, as you heard the testimony, there's explosives here several feet behind the hut, children are in, and there's a little lifter thing. You remember seeing the movie, there's a ladder there, and they put a little lifter to push the ladder over to make it appear that part of the hut was blowing up. Mrs. DeAugustino told you that the children were 3 or 4 feet from the explosions. Now that's, maybe she meant from the explosives, but that's simply not true that they were 3 or 4 feet from the explosions. As a matter of fact, if you remember, Mr. Morrow goes in, picks up the children, runs back here beyond the camera, and then the explosion goes off back here, and then the little lifter thing goes off there. The cameras, according to the testimony, the cameras are placed right here on the water's edge, so that they'll run by them just into the water, and then the scene is cut. Now, where was the helicopter at this time? You have heard the people testify, and I think it's without contradiction, that we drew a circle right there. The helicopter stays right there now where I've drawn the circle on 500 that says 9:30. That was the location of the helicopter. Before this scene was shot, Mr. Landis met with the parents and the children and told them what was going to be shot, how it would be shot. Mrs. DeAugustino suggests that there was some danger having the children here, but you heard the witnesses, the special effects experts, say that until they're right ready, a second or two before the explosions, before the scene is to be shot, the wires on the special effects are shunted so that they cannot go off. Then when the scene is planned, the cameras are there, the parents, Mr. Landis has explained to the children and to the parents, they have the rehearsals. And my recollection is that there were several rehearsals of this scene. When the rehearsal is over, the two cameras here, then they say action. Mr. Morrow goes in, picks up the children, runs out beyond the camera, just into the water, and the special effect back there goes off, and the little lifter goes off about here. It's filmed, and the scene is over. There is no problem. Now again, this is the second time the children are being used on the set with 6 fire safety officers, and the fire safety officers, again, say that they did not see any children. It took a long time to do this, or after this, to set up for the next scene. The next scene is the 11:30 scene. Now, the reason it took some time after the 9:30 scene up until approximately, and these are, when we refer to the 9:30 scene, the 11:30 scene, and the 2:20 scene, this is sort of a shorthand way of getting the scenes, and you all understand that. It doesn't mean they happen exactly at 9:30 or 11:30 or 2:20, but I'll go to keep referring to that because it seems to make sense. It's a way to identify it. So there is some period of time between 9:30 and 11:30 scene. What they were doing, if you remember at the 9:30 scene, there were just a couple of cameras right here on the village shore. For the 11:30 scene, they were moving cameras back across the river so that they could get a wider view for the 11:30 scene. Now, at the 11:30 scene, Mr. Landis again has a meeting with Mr. Larner, Mr. Cohn, Mr. Stewart, and Mr. Wingo, and he describes the 11:30 scene. Then he locates the helicopter, which, as Mr. Wingo pointed out, is where I've got H at 11:30, that the helicopter is located right on the shoreline. You remember he said that it was located so that the very middle of the fuselage the shoreline would actually bisect the middle of the fuselage in the helicopter, where I've marked it H1130 on Exhibit 500. Now, this is Mr. Landis explaining the scene, where the helicopter is going to be, and so forth. Then, according to Mr. Landis's explanation, Mr. Stewart then explains that there will be explosions back here near the cliff, 1, 2, and 3. And there would be 2 explosions here, hand grenades or grenades in the water. They point out that Mr. Vic Morrow will be in here, partly in the water and partly off of the water, and they locate him particularly there and point out his path. At that point, when they were discussing the 1130 scene, here's something else happens, and I'll ask the question again. Mr. Morrow gets with Mr. Wingo and wants to throw a stick at the helicopter. It's obvious that Mr. Wingo doesn't want that done and attempts to nicely point out to Mr. Morrow that wouldn't be a good idea and would have ultimately turned it off. But Mr. Landis hears that and says, no, don't throw a stick at the helicopter. Does that sound like reckless conduct to you? And the cues. The cues are that action will be called first. Mr. Morrow will then scream at the helicopter and wave to the helicopter, thinking that the helicopter will recognize him as American. And then the next cue is for the machine guns to fire, and the machine guns then start to fire with the helicopter here, and these special effects then start to go off. According to Mr. Landis, they then rehearse the scene. Now let me tell you something here that there is a difference. Mr. Wingo has a different recollection of that. And I am telling you right now that's an indicia of truthfulness for both of them. If they were going to get their stories together and remember that everything happened exactly the same way 4 or 5 years ago, you would know that sounds fishy. Mr. Wingo says, my recollection, it happened this way. We had a meeting, the same people, Mr. Wingo, Mr. Landis, Mr. Stewart, Mr. Cohn, Mr. Allenham, and Mr. Larner. And he says we described the scene, and then we decided that we would made a brief description of the scene. We would decide we'd bring in the helicopter, we would place it right there where Mr. Wingo says it was placed, get that lined up, and then we went back, took the helicopter back after it was lined up, and then we had a full meeting where the explosives were located by Mr. Stewart for Mr. Wingo, 3 at the base of the cliff the same way, 2 what he called grenades along the shoreline. They again, according to Mr. Wingo, describe Vic's path and the cues that would be made. So there is some slight variation there between what Mr. Wingo remembers and what Mr. Landis remembers. But the variations are insignificant. They both agree that there was a full description of the scene, that they knew where the special effects are, that the helicopter came in right there, right on the shoreline. Now then, what happens? After all of that's described, we then go to the scene. The helicopter comes in where I've marked it on Exhibit 500. The action starts. The cue is given to action. Mr. Morrow waves to the helicopter and screams to the helicopter, friend, friend. And then the second cue is given for the machine guns to start fire and for the special effects to go off. At that point, Mr. Wingo or some of them on the helicopter felt some heat from these special effects 1, 2, 3 back here, and he got water on the windshield. Now, Mr. Wingo, I believe, told you that he knew there would be these grenades or mortars here. He just did not realize that they would throw water that high. And he leaves the scene, and the scene is over. At this point, and this is something that I would ask you to remember, at this point, Mr. Landis, the helicopter's now going on back. Mr. Landis does not know there's been a problem with the 1130 shot. And while the helicopter's going on back down here, and you can see this, by the way, in the film clips, Mr. Landis has been on the spit here while the 11:30 scene is being filmed. At that then, at the moment the helicopter leaves and the filming is over, Mr. Landis goes across here to round the end of the pier, near the pier there on Exhibit 500, and they hold a meeting to discuss what we've called the 220 shot. There at that meeting is Mr. Landis, Mr. Stewart, Mr. Cone, Mr. Goldenhar, and safety officer people were in their places at the rehearsal. 4 of them up on the cliff up here. Mr. Tice, part-time, was right in here around the sampan, and part-time was right over there with Mr. Stewart right by the number 4 structure. Mr. Rimmer is in the area down here somewhere. Not only the fire safety officers were there during the rehearsal, not only were the special effects people in their place, but the camera people were in their place. And this scene was filmed, as you remember, by 6 cameras. There was a camera up here on the cliff. I'm pointing to the left-hand side of Exhibit 500 now. There was a camera up here shooting down this way. There was a camera basically on the ground across the river here. There was B camera up in the air on the Chapman crane. There were 2 cameras upriver here. Let's see, how many is that? 1, 2, 3, 4, 5, and there was a camera in the helicopter. 6 cameras. The camera people were all in place, like the others, for the rehearsal. So the plan has been described in detail, it's been rehearsed in detail with all the people playing in their place. Mr. Chamomile, who holds the number 1 powder card, was advised, as I have told you, and the cameras were placed. Now, the other thing I should mention are the 5 critical special effects. Mr. Craig Melvin, or Sergeant Craig Melvin, came on, and using an overhead projector, testified where the 5 critical special effects were. And I think you'll remember that rather than go through using an overhead camera, I just said, well, let's mark them down here on Exhibit 500, because it's a whole lot easier for all of us to minimize the number of exhibits if we can. And Mr. Craig Melvin put special effect number 1 right there, where I'm pointing to number 1. Special effect number 2 right there. Special effect number 3 right there. Special effect number 4 right there. And special effect number 5 right there for the 220 scene. Now, Mr. Wingo has made sure everything is tied down. The helicopter now has been fully rehearsed, and it's back here somewhere on its landing pad waiting for instructions. What is the next thing that happens? Mr. Landis meets with the parents and the children in this area I'm pointing to now. We can call it the lagoon or around the spit where the image of the helicopter is on Exhibit 500. He talks to the parents here, as you've heard the testimony. He explains to them what the scene is going to be, and then the children and Mr. Morrow are taken right over here on the edge, because everybody assumes that the scene now is ready to start. They've rehearsed it at around 2 o'clock, and the rehearsal's over. Mr. Morrow and the 2 children are right here. Mr. Landis is right here on the spit of land where it's been marked with that thread, and they're ready to start. At this, Mr. Tice comes up to Mr. Landis and says, Mr. Landis, we've got to wait. A fire safety officer, Mr. Hull, is still eating. And Mr. Landis waits with the children here and Mr. Vic Morrow here, and him talking to Mr. Tice right here. Now, Mr. Tice acknowledges that. Well, he doesn't acknowledge the children over there. He acknowledges he talked to Mr. Landis here, and then as Mr. Sanders says, he saw Mr. Landis talking to Mr. Morrow, but according to Mr. Tice, he never sees the children right here. you'll have to judge that for yourself. In any event, Mr. Landis says, okay, we'll wait. And while we're waiting, Mr. Landis leaves here, goes back over, and talks to Mr. Morrow and the children right here. Now, we're only talking of a matter of a few moments now. Mr. Landis goes over there to talk to Morrow and the children while Mr. Hull finishes up his soup or whatever it is and gets back to where they're going to be. Mr. Landis then comes back over to the spit. He tells everybody to stand up. You've heard the testimony that Mr. Landis does this on all action shots where there's moving machinery, cars, etc., as a routine safety precaution. Now, Mrs. DeAugustino would tell you that a routine safety precaution is somehow, in her mind, becomes knowledge of danger. That's what happens sometimes in the hands of a clever prosecutor. And Mrs. DeAugustino is that. So Mr. Landis comes back on the spit now. Mr. Hall finishes his food and goes back and takes his place, and the signal is given for the helicopter to take off. The helicopter takes off, and it comes, as I told you, or suggested to you, comes right here where it was, at the edge of the sampan, right where it was at the 2 o'clock rehearsal. Now then, Mrs. DeAugustino says, ask Mr. Landis, didn't he say at the NTSB, well, the helicopter's not quite in the same spot, but I don't care. Mr. Landis says, yes, I said that, but what I meant was it was slightly back, slightly towards the dam, rather than being right up over the sampan. It was slightly back towards the dam, but it was no closer to the village, and therefore when I said I didn't care, I meant it's being back this way towards the dam doesn't increase any danger whatsoever, and it doesn't interfere with the shot, and if he wanted to be back a little bit towards the dam, I didn't mind. And Mrs. DeAugustino said to you, but he didn't explain this in the NTSB or the grand jury. I objected. My objection was sustained.
Objection, Your Honor.
I objected. The objection was sustained, and Mrs. DeAugustino says, oh, I misspoke myself. Now, the helicopter comes in, hovers here, and then, according to Mr. Wingo, he hears lower from somebody, and the helicopter descends approximately 6 feet. Mr. Wingo told you, and let me tell you right now, I submit to you, this idea that a lowering of 6 feet from the 11:30 scene is somehow dangerous, I say it is a phony issue. Mr. Wingo told you that he expected to be lowered a little bit when he came in here, and he was lowered approximately 6 feet. He said it was not dangerous, any more dangerous at 6 feet than where he was at 11:30. Mr. McKern and Mr. Webster, extremely fine helicopter expert, says that's not dangerous, no more dangerous to be there at all. And you know something? What was significant? Mrs. DeAugustino brought on 2 helicopter experts, a Mr. Gavin and Mr. Gamble, and she didn't even ask them about this lowering 8 feet or whether that somehow was dangerous. As I say, Mr. Wingo told you. He came in here to hover and knew he was going to be lowered about 6 feet. Now, when I say that Mr. Wingo brought the helicopter in over the sampan where he was stationed at the 2 o'clock rehearsal, let me show you Exhibit 503, which shows you where the helicopter in fact was at 2:20 when it was hovering. Exhibit 503. There is another exhibit, 504, where he is in the same place, and you can see the special effects start to go off here. Exhibit 503 and 504, and you can see where the helicopter is. And you can notice that right up here is up in this area right in here, I'm pointing to now to the left of this picture, is where Mr. Chamomile was on the berm. The cue is given for action. The first action. The helicopter is here, everybody's place. Mr. Morrow starts out with the children here. When he gets a safe distance away in the river, somewhere apparently near in here, pointing now at 500, the second cue is given for machine gun fire. The machine guns with the helicopter right here, right over the edge of the sampan, the machine guns start to fire. Now, let me pause right there and say to you that perhaps the best proof on this particular area is from the FBI agent Gerald Richards, the man who had all the charts and the wavy lines like that. Without going through all the charts and the wavy lines, he said to you, and he was brought on by the prosecution, that that helicopter came in there and it hovered rock steady as 3 explosions went off back here. 1, 2, 3. Had not moved, and during those 3 explosions against the cliff, there was no heat, no question of heat, or no water problems. These explosions back here, I believe, was testified, were about a second and a half apart. After the 3rd explosion goes off, the helicopter turns in this direction to the northeast. And something that'll be significant to you, to show you later on when I get to Mr. Chamomile. There were 3 seconds that elapsed between the 3rd explosion and the 4th explosion. A second to a second and a half between 1 and 2, and the same between 2 and 3, but 3 seconds between 3 and 4, indicating that Mr. Chamomile had been told, look, you've got to pause between 3 and 4, because the helicopter, remember, is going to be a safe distance away before you set off those on the shore. And as he admitted, that Mr. Stewart told him, whatever you do, don't set off a special effect underneath the helicopter. Now, so the helicopter's here, special effects go off. 1, while the hovering's going on, Mr. Morrow and the children out here, spotlight on. 1, 2, 3, the helicopter, according to Mr. Richards, is rock steady. After the 3rd explosion, remember my opening statement, and as I say, I'm here to redeem my promises made. I use my glasses here. After the 3rd explosion, the helicopter turns like this and starts in its northeast direction. As it turns and starts forward, the 3 explosions have gone off. Mr. Morrow's out in here. I asked Mr. Richards, well, Mr. Richards, let's assume this plan, and I gave him the same plan I've told you several times about. Would you say that until the 4th explosion went off prematurely, the plan had, what you saw, analysis of the film, was exactly what I told you and asked you to assume as the plan? And he said, yes, up until the 4th explosion went off, what I saw indicates that the plan was followed exactly. And he said that at transcript page 18,148. 18,148. I told you this morning that there were 3 critical issues in this case. A lot of proof went on that appeared not to be directed to these 3 issues. I said that the three critical issues on which I submit on the evidence, should decide the case is, did the defendants reasonably believe the plan for the 220 scene was safe? Was it adequately rehearsed? And third, did unforeseen and unforeseeable events intervene to cause this tragic accident? I have talked now about the proof of two of those: the plan, the reasonable belief that it was safe, the full rehearsal, and now comes the unforeseen and unforeseeable events. Although he'd been told to wait, to not set off any special effects underneath the helicopter, whatever you do, without looking at the helicopter, Mr. Chamomile sets off number 4, and while the helicopter is right in here, going to the northeast, moving forward. He sets off number 4, so that's one thing that happened. How could anyone foresee that a man holding the highest powder card issued by the state of California, the number 1 expert in his field, would not follow instructions, would not follow the first principle of his profession, and I'll get to in a minute, and would prematurely set off a special effect with the helicopter right there? The next thing that happens is that Mr. Chamomile sets off 4 and 5, according to Mr. Richards, and I quote him, for all intents and purposes at the same time. He says, if you want to be hyper-technical, there was 1/10 of a second apart between number 4 and number 5 with the helicopter right in here. The next thing, the next unforeseen and unforeseeable event is that number 5 misfires. What we've been calling a misfire, I guess I should explain, because misfire may be somewhat misleading, although it appears to be a misfire. What happened was that special effects, this 6-ounce black powder bomb with the sawdust, gasoline-soaked sawdust on top of it, the bomb is supposed to ignite, and the sawdust is supposed to ignite right there in the mortar. What happened to number 5, which totally, unbelievably unforeseen, is that for some reason the sawdust did not ignite at the mouth of the mortar. The sawdust, with the gasoline-soaked sawdust, went up in the air and caught the number 4 mortar fireball and ignited up in the air around the tail of the helicopter to combine in a fireball right around the tail of the helicopter. The third unforeseen and unforeseeable event. And the fourth, or fifth, is that the fireball engulfing the tail rotor caused the delamination of the tail rotor blade, heat delamination. And if it's one thing that's undisputed in this case, it is that nowhere in the recorded history of helicopters has there ever been a report of a tail rotor blade delaminating from heat. It happened here in the Twilight Zone. With that, the helicopter was out of control. Some other lawyers can explain what happens if it twirls around like this. I won't go through that. Simply out of control, and it crashes right there. I think 5 feet from where Mr. Landis was standing. So, those are the unforeseen and unforeseeable events. A premature detonation of special effects by Mr. Chamomile, the detonation of number 4 and 5 at the same time, number 5 misfiring, and the tail rotor blade of the helicopter delaminating. Because Mrs. DeAgostino, and I want to tell you something now that I'll get to again in a minute. I don't think Mr. Chamomile is a criminal. I don't think we're not trying to blame him. We're trying to tell you what the proof shows happened in this case. But Mr. Chamomile did certain things, and perhaps the best thing to do is to see and hear from his own mouth what happened. The last time you heard Mr. Chamomile was back a long time ago, sometime in 1986. And because Mrs. DeAgostino said something in her summation that might indicate to you that there is some equivocation about what Mr. Chamomile said, I had his testimony, not all of his testimony, of course, but I had his testimony blown up. And I submit to you, there won't be any contradiction about this. And I've got the transcript. They did not see any children. It took a long time to do this, or after this, to set up for the next scene. The next scene is the 11:30 scene. Now, the reason it took some time after the 9:30 scene up until approximately, and these are, when we refer to the 9:30 scene, the 11:30 scene, and the 2:20 scene, this is sort of a shorthand way of getting the scenes, and you all understand that. It doesn't mean they happen exactly at 9:30 or 11:30 or 2:20, but I'll go to keep referring to that because it seems to make sense. It's a way to identify it. So there is some period of time between 9:30 and 11:30 scenes. What they were doing, if you remember at the 9:30 scene, there were just a couple of cameras right here on the village shore. For the 11:30 scene, they were moving cameras back across the river so that they could get a wider view for the 11:30 scene. Now, at the 11:30 scene, Mr. Landis again has a meeting with Mr. Larner, Mr. Cohn, Mr. Stewart, and Mr. Wingo, and he describes the 11:30 scene. Then he locates the helicopter, which, as Mr. Wingo pointed out, is where I've got H at 11:30, that the helicopter is located right on the shoreline. You remember he said that it was located so that the very middle of the fuselage the shoreline would actually bisect the middle of the fuselage in the helicopter, where I've marked it H 11:30 on Exhibit 500. Now this is Mr. Landis explaining the scene, where the helicopter is going to be, and so forth. Then, according to Mr. Landis's explanation, Mr. Stewart then explains that there will be explosions back here near the cliff, 1, 2, and 3. And there would be 2 explosions here, hand grenades or grenades in the water. They point out that Mr. Vic Morrow will be in here, partly in the water and partly off of the water, and they locate him particularly there and point out his path. At that point, when they were discussing the 11:30 scene, here's something else happens, and I'll ask the question again. Mr. Morrow gets with Mr. Wingo and wants to throw a stick at the helicopter. It's obvious that Mr. Wingo doesn't want that done and attempts to nicely point out to Mr. Morrow that wouldn't be a good idea and would have ultimately turned it off. But Mr. Landis hears that and says, no, don't throw a stick at the helicopter. Does that sound like reckless conduct to you? And the cues. The cues are that action will be called first. Mr. Morrow will then scream at the helicopter and wave to the helicopter, thinking that the helicopter will recognize him as American. And then the next cue is for the machine guns to fire, and the machine guns then start to fire with the helicopter here, and these special effects then start to go off. According to Mr. Landis, they then rehearse the scene. Now let me tell you something here that there is a difference. Mr. Wingo has a different recollection of that. And I am telling you right now that's an indicia of truthfulness for both of them. If they were going to get their stories together and remember that everything happened exactly the same way 4 or 5 years ago, you would know that sounds fishy. Mr. Wingo says, my recollection, it happened this way. We had a meeting, the same people, Mr. Wingo, Mr. Landis, Mr. Stewart, Mr. Cohn, Mr. Allenham, and Mr. Larner. And he says we described the scene, and then we decided that we would made a brief description of the scene. We would decide we'd bring in the helicopter, we would place it right there where Mr. Wingo says it was placed, get that lined up, and then we went back, took the helicopter back after it was lined up, and then we had a full meeting where the explosives were located by Mr. Stewart for Mr. Wingo, 3 at the base of the cliff the same way, 2 what he called grenades along the shoreline. They again, according to Mr. Wingo, describe Vic's path and the cues that would be made. So there is some slight variation there between what Mr. Wingo remembers and what Mr. Landis remembers. But the variations are insignificant. They both agree that there was a full description of the scene, that they knew where the special effects are, that the helicopter came in right there, right on the shoreline. Now then, what happens? After all of that's described, we then go to the scene. The helicopter comes in where I've marked it on Exhibit 500. The action starts. The cue is given to action. Mr. Morrow waves to the helicopter and screams to the helicopter, friend, friend. And then the second cue is given for the machine guns to start fire and for the special effects to go off. At that point, Mr. Wingo or some of them on the helicopter felt some heat from these special effects 1, 2, 3 back here, and he got water on the windshield. Now, Mr. Wingo, I believe, told you that he knew there would be these grenades or mortars here. He just did not realize that they would throw water that high. And he leaves the scene, and the scene is over. At this point, and this is something that I would ask you to remember, at this point, Mr. Landis, the helicopter's now going on back. Mr. Landis does not know there's been a problem with the 1130 shot. And while the helicopter's going on back down here, and you can see this, by the way, in the film clips, Mr. Landis has been on the spit here while the 1130 scene is being filmed. At that then, at the moment the helicopter leaves and the filming is over, Mr. Landis goes across here to round the end of the pier, near the pier there on Exhibit 500, and they hold a meeting to discuss what we've called the 220 shot. There at that meeting is Mr. Landis,